work.
315 and 314 for a shooting at Century Theaters. They're saying somebody's shooting in the auditorium.
Roger, keep your fires west of the smoke. You're cleared hot. An officer hit. Send me the world.
Don't go over that fence. Don't go over that fence. Grab the shotgun again.
Welcome to Tactical Tangents.
Welcome back to Tactical Tangents. This is Mike and Jim. Today we're going to talk about going to court. As a general rule, we try to make our podcast relevant to as many people as we can, but this episode is hopefully going to help police officers go to court and finish the job in terms of putting bad guys away, and that is such an important part of the profession. It's one thing to get your confessions or to put the pieces together and identify who your suspect is, or even to catch up with them in the wee hours of the morning and chase them down in an epic game of cat and mouse with the sore back and knees to prove it. Believe me, I love those games. I live for those games, but they are all for nothing if you can't show up in court and effectively communicate what you saw or what you did to a judge and a jury in a compelling way. And this is something that goes back to many of the core things that we talk about when it comes to leadership or being a good teacher or interacting with the public in a way that gains their trust. So I think you're going to see a lot of those things come out in this discussion. This episode is brought to you by Mantis. Mantis is a firearms training system that detects the movement in your gun immediately before and after each shot. My favorite part about the Mantis is that you can use it in dry fire, and I spend a lot of time working on my draw to first shot from the holster using their holster draw analysis feature in the X10. You can go check them out at mantisx.com for data-driven performance.
This episode is also brought to you by Drip Drop Oral Rehydration Solution. It's formulated by a doctor for quick absorption of water into the parts of your body that need it the most. You can find it on dripdrop.com or even on Amazon. And I would offer, if you're military or law enforcement and your organization is training or operating where it's hot out, have your supply guy buy it for you. It's available on GSA Advantage or through the NSN National Stock Number System.
Our guests today are Jonathan Mosher, Chief Criminal Deputy County Attorney in Pima County. The term county attorney might be unfamiliar to some of you. It's the same thing as district attorney in some places, but he's one of the guys who takes serious violent offenders who get rolled up by the cops, and he presents those cases to judges and juries to get them convicted and locked up. Now, Jonathan's been doing this for a long time, so the sorts of cases he's usually dealing with these days are things like people who shoot police officers and other high-profile cases. There was one involving a former fire captain who murdered his wife and two others, and there was also a University of Arizona athletics coach who assaulted one of his athletes, and those are just a couple of examples. And as it happens, Jonathan is also running for office to be the county attorney this fall to fill the vacancy that will be created by Barbara Lawal's retirement. And my friends in places who know better than me tell me that Jonathan is the best prosecutor we got. So hopefully by the time many of you hear this episode, he will be the top dog at that organization. And he certainly has my support, and I'm rooting for him. He's got a long history of putting violent offenders away and puts a lot of time and effort into teaching and training, from what I gather. So he's definitely our kind of guy. And also joining us is Homicide Detective Josh Cheek. Josh is one of the most respected and experienced detectives who works in the homicide unit at my agency, which, cough, cough, shall remain nameless, of course. And we have to make sure that we're clear here that we're doing this as an off-duty, unofficial thing, that our views or positions don't represent those of our agency. That might not apply to Jonathan since he's about to run his organization, but it absolutely applies to Josh and I. Josh has been a police officer for over 20 years. He's worked in surveillance, auto theft, narcotics. He's also one of our hostage negotiators. So he's been around for a while and has also helped in locking people up for a long time. So here where I work, homicide detectives are also the ones that investigate or who investigate officer-involved shootings under the guidance and supervision of the county attorney's office. As I understand it, they can talk a little bit about that. And ultimately, they present the facts to help determine the justification for those shootings and whether or not charges will be filed. So that is an assignment that we all hold in high regard because those sorts of investigations are in many ways a big part of the way we establish and retain the trust of the community we work in. So thanks for being here, guys.
Thanks for having us.
Yeah, thank you.
The A-team rides again.
Right. That's right. So a lot of cops get to hear my perspective all the time on the show, and I'm just a silly dog handler and SWAT nerd. So can you guys talk to us about your roles in the criminal justice system? Why do they matter, and what's at stake?
Yeah, absolutely. So as a detective, what I try to remind people if I'm teaching at the detective school or if I'm dealing with newer detectives or less experienced detectives or officers who want to become detectives, I think the main thing that people lose sight of is that our job is to seek the truth. Our job is not to put people away. It's not to arrest bad guys or to prosecute people. We seek the truth. And we seek the truth, whatever that truth may end up being. And that's really a superpower in a lot of respects, because if you're seeking the truth, then a defense attorney at trial can come at you with whatever defense they have, whatever questions they have. They can get aggressive with you. They can be rude. They can be arrogant. They can be dismissive. But it doesn't matter. You're there for something that's bigger than that. And you don't have a bias. You're not there to achieve some goal. You don't approach an investigation and say, I'm going to put this guy away, so let me figure out how I can do that. You're there to figure out what happened, to gather and collect that evidence, and then present that to a jury at trial and explain what the evidence shows, what evidence there was, and what that means, and what you did from that point on.
I love that.
Yeah, I mean, this is why I love working with Josh. That sums it up great. We are in a time when public distrust of police and prosecutors has increased. And I've seen that over the course of my short 15 years working as a prosecutor. I'm now the chief criminal deputy. I'm on leave of absence, actually, to run for office. But, before I was chief criminal deputy, I was chief trial counsel, and I've been handling big, bad, scary cases for a long time. And yet, we, over that period of time, somewhere along the way, lost public faith in ourselves as prosecutors, at least in degrees. Because when I started prosecuting in 2005, I would walk over to court. It was a different time then. It was easier to go to court with a case because you didn't have some of the technology that we have now. So we didn't have some of the digital evidence that we enjoy. I mean, I was trying cases with Polaroid photos and stuff. But you could just take a little simple case file, walk over to court, and if you were dealing with an armed robbery, a carjacking, a shooting, you could rely on the fact that the jury would like you and they would like the police officer sitting next to you. And in 15 short years, that has changed dramatically. And when you notice it is in jury selection. You're asking questions about what are your attitudes about police, and that changed. And it's not hard to figure out why it changed. I mean, in that 15 years, we've had Duke Lacrosse, a compelling example of prosecutorial misconduct. We've had Ferguson, Missouri. We've had Trayvon Martin. We've had wrongful convictions coming to light. We've had it emerge that the war on drugs has some real brutality to it as well. I would argue, inhumane components. And so through all this, I believe there's been a public awakening that they want more from us. And what they want is exactly what Josh just said. They don't want to know that Josh is out there to get the bad guy. I mean, that's part of his job. But they want law enforcement to protect them and their children and families. But they want us to be compassionate, to act with integrity, to be transparent. And so I'm excited to be on the podcast because this is what we can accomplish in these discussions, is we can get that message out about, and because Josh and I have some real ideas on exactly how to do that when you interface with a criminal case, taking it to trial. So we will get to the nuts and bolts, but it's fun to start at this high level of the why we're having this conversation and why you should be interested in it.
The public faith thing, actually, it gives me a couple of follow-up questions I'd love to ask you. One is the situations you reference are mostly nationwide issues, and it is a nationwide issue. That the faith people have in prosecution and law enforcement is a problem across the country, and it's one of our big goals on Tactical Tangents is to figure that out and have a more nuanced approach to it and help law enforcement explain itself better. And I'd be interested to hear whether you have any insights on whether there are local problems too. Was there anything locally around Tucson, around Phoenix, or greater Arizona that you think contributed to that? Question one. And my follow-on is also CSI effect. Is that having any tangible effect of people watching TV shows and saying, well, how come you don't have DNA on this shoplifter?
So with respect to the first question, has there been a local incident or incidents that have caused public faith in law enforcement to erode? I mean, I guess the short answer I would give is that that might be barking up the wrong tree only because of the power of social media and the fact that we all now we're one step away from having our phones implanted in our brains, people. Let's just be honest. I mean, everybody has access to all of these examples that I'm talking about across the nation. Now, that is not to say that there have not been some pretty high-profile examples of use of force incidents in the Pima County area that have gotten public attention. I mean, there's one of note within the last few months that caused a real outcry. I mean, there was a young man who was African American and a quadruple amputee who was, tackled by a sheriff's department deputy, and that received a lot of attention. Okay, so I am not going to sit here and say that we haven't had local issues. I will say this, though. I don't know if I'm allowed to mention agency names, but we have a local police agency in the town of Tucson, and the leader of that agency is, and I come into this, and I know you guys are tactical tangents, and you have a lot of SWAT and use of force expertise, and I'm just a simple prosecutor. But from where I'm sitting, our local police chief is quite progressive, and our neighborhood policing is really state of the art. And I bring that up because I say, and yet when I go into neighborhoods, because of my campaign, I'm all over town, and when I go to neighborhoods and I attend an African American church, and when I talk to folks, they're concerned about police and prosecutors. So this is a local issue. I want to emphasize that even if the drivers of it have primarily occurred outside of Tucson, it has the rapt attention of people in Tucson. For sure.
That was very well said. You should be a lawyer.
It makes the whole world smaller.
Yeah.
So like what we would consider a national issue becomes very local when everyone has their own feelings about it.
Absolutely.
Across the room or across the street, for example, or whatever.
Yeah.
Right. Yeah. And I think when anybody here in Tucson sees a clip on YouTube, that it doesn't matter if it happened in St. Louis or Chicago or California somewhere. If I'm out on a scene, somebody who has seen that video, they see that as being somebody that I work with. Like, that person who is working in law enforcement represents somehow all of us, and it represents me. And I mean, anybody who works in law enforcement, I think, has experienced that. Patrol officers more than most. Everybody pays the price for those people who make those poor decisions in a split second.
I think there's a nationwide misperception that all the agencies are all one big agency and they'll answer to like the federal government, that sort of thing. I don't know how to word that, but I see it. I see it all the time on Facebook. So.
Well, I think, what I like to do is I like to look at, all right, yeah, there's misperceptions and there's wrongful attitudes about police officers. But what I like to do, or prosecutors, is I like to look at my side of the street. And instead of complaining about defense attorneys, I like to make sure I know what I'm doing first and foremost on my side of the street. And what Josh just said in the opening, where he said he's in a search for truth. He's not there to put bad guys away. Higher than all of that is a search for the truth. He's right that it gives people superpowers. It gives them superpowers on the witness stand when police officers testify if they have that attitude. And we'll talk about that later. But what he's talking about by way of an introduction is putting on a new pair of glasses that will restore public confidence in police and prosecutors. And the way that we will do that is to stop talking about ourselves in the way that we talked about ourselves 10 or 15 years ago. We got to change with the times. And what I mean is that he just said it, folks. We're not out to put bad guys away. I mean, look, I got to be honest with you. I've been in the trenches fighting really nasty crime. And although when I say that, I'm cognizant of the fact I'm talking to SWAT guys who are out there actually getting shot at, and I'm not getting shot at. But what Hopefully. I do mean is I probably have a better cross-section than anybody sitting on this podcast right now of a really nasty crime, because that's all I've been doing for over a decade. Rape, fatal child abuse, child molestation, like egregious examples, like that could really make your blood boil. Violence of all kinds, mostly fatal. And so, even though I have that perspective, I have to say, bad guys, okay, I run into some, but a lot of times we're dealing with a human being who made some really bad decisions and usually is addicted or on drugs and alcohol. I'm not saying that's a way of an excuse, but if we start thinking about ourselves as responding to conduct and incidents and stop thinking of we're the good guys and on the other side are a bunch of bad people, we're getting ourselves in trouble with that kind of thinking. So let's change the language around those sorts of things. Far more often, you're going to be running into, I've been talking too long, but let me back up for 1 second.
Yeah.
I had the honor and privilege, and I do mean those words, of working with Josh Cheek on a case involving a nearly fatal shooting of can I say the agency?
Yeah, you can say whatever you want.
Yeah, so Tucson Police Department officer shot in the head, nearly killed, and an inch away from losing his life. I had the honor of working on that case with Josh Cheek. And when I say honor and privilege, it's because he's the best in the business, and I will eventually let him talk, I swear. But in the course of that case, we had to do a scene visit. And we went to the south side of Tucson to a very challenged neighborhood. It is a rough neighborhood. And the way that Josh went up to every person he encountered and started a conversation and checked in on them, whether they had a scary pit bull around or whatever. I mean, it was inspiring to me. I had an epiphany about what it means to be a police officer in Tucson, watching him walk through that neighborhood and interact with people, some of whom, no doubt, had really negative perceptions of police, but when they met Josh that day, they didn't. And that's what I mean, is he wasn't looking at people and making a judgment. He's just doing his job. And so we have to start being a little bit more of ambassadors for ourselves and our mission, which is a righteous one and a just one, because there are horrible people that will do terrible things. But there's a lot more people who we serve. And that's the exciting part of the work, right?
Those are well put thoughts. I think there's a lot of people that I talk a lot about catching bad guys because it's a lot of what I end up doing. I run out with my dog and my SWAT buddies, and that's what we do. Once I have the target, right? Like our job is to go get the target. Yeah. See the rabbit, chase the rabbit, right? Absolutely. And I live for that. I love that part of my job, but it is at the same time, 9 times out of 10, it's for a purpose and an objective, and I interact with those people, and it's just another dude. And most of them don't really have all that bad of intentions, other than the fact that, like you said, they've made mistakes, and they've just, these things start to all kind of snowball on top of each other. And a lot of times they're pretty personable people. I've had people apologize to me for getting bit by my dog, and they're like, "I'm sorry," and I'm like, "For what?" I mean, you ran from the police. I mean, I was going to catch you one way or the other. I mean, I prefer that you give up, but it is what it is, right? But I think, speaking to what you said about taking care of your side of the street, that's huge for me. And the analogy I use for this when I talk to cops is think about how good you expect a professional sports player to be. If I teach a room full of cops, I ask them, like, how many of you watch sports? I'm not a big sports ball guy, but if you're into sports and you watch sports, how many of you have an expectation of how good a professional quarterback is? Whoever your favorite, right? You have an expectation that they're going to perform a certain way. And even though you're not the guy or the gal in that arena, that expectation still holds true. And I think that speaks to our profession in law enforcement. It's not really about how you feel about what they think so much as you making sure that you're taking care of the nobility of the job and that you're received well, right? And that's on us. That's on us to do correctly. I don't think that, even though they might be quick to judge, or even though, it's not, don't make it about them, make it about you and taking care of your own self, right? If you think you're better, then act like it. And I think that's a huge part of the message I think cops need to hear out of this is that, are there people out there that make the job more difficult? Sure. But work through it. Like, this is what we do, it's what we signed up for, and it's important.
Yeah, and then I think the second part of your question was the CSI effect and how big that is. I mean, that's a huge factor at trial. It influences decisions that we make during the course of an investigation. It influences how we present a case at trial. It influences testimony, and it ultimately influences all of that.
And just to give our listeners a sense who may not be familiar, to do a quote unquote DNA match, about how long does that take, and about how much does it cost?
Go ahead.
Well, I'm begging to let us do the opening spiel for the class, because you're actually at 1 hour into the class.
Oh, my bad.
There's some education that needs to be done for the attendees before we get there.
So you guys teach a class. You guys want to tell us about that?
Yeah. So I was asked long ago to give some instruction to police department officers and detectives who would be coming in and testifying at trial. And I did that for a while with, I'm sure, mixed reviews because I didn't understand what was required to talk to cops about coming to trial. And it took me a while to put it together. And so I want to give you that opening, all right? Because police officers, unlike almost any other group that I talk to, are quite tough and very able to handle the truth. In fact, they demand it. So if you walk in to a room full of cops and you confront them with the truth, you will have good results. So here's how it goes. And you have to picture we have PowerPoint slides. And so I put up a PowerPoint slide after I've introduced myself, and it has SWAT on it. It has pictures of people doing really exciting things. I mean, frankly, I'm jealous. Okay, I wish I could live two lives, and one of them I would be a SWAT officer, right? I mean, so
you mean you want to come sweat your balls off in July at the shooting range all day and 60 pounds of gear? That sounds awesome.
I just ran for 2 hours in 105-degree temps. It's not quite hot enough for me yet, but I don't mind the heat, my friend.
There's a reason we work with Drip Drop Oral Rehydration Solution. It's because it's hot as balls.
I need some
of
that stuff, I'm telling you.
Yeah.
Do I get some Drip Drop for the appearance? Hopefully.
Yep, I got some up.
We can work that out.
I'll give you some.
So, PowerPoint slide, SWAT, exciting activity. Look, you went into being a police officer because you wanted to serve your community and you wanted to protect people from those who would do them harm. You were excited about that. That's why you're here. And then I put up another slide, and it's got a police officer getting yelled at by people, civilians, and then it's got a different photo of them doing paperwork. And it's like, but you kind of lose sight of that mission, right? Because you have a bureaucracy like we do in every line of work, and sometimes you feel squeezed between the people you're trying to protect and the bureaucracy. I mean, you've got people like spitting in your face and calling you names, and you're actually just trying to help them. And so that can have a wearing down effect. And then the next slide is a picture of the courthouse. And you're talking about, look, so coming to court is not that fun. And all of this causes you to think, I got to go talk to the attorney. Mosher, the attorney, the little pinhead attorney, he doesn't do what I do. He doesn't jump fences. He doesn't get shot at. He doesn't know what I'm going through. I got to go to court and put up with this nonsense. And it leads to a lack of love, let's say, for coming to court. And when you start out like that in a room full of cops, let me assure you that I can palpably feel that they agree. And then they're laughing, and they love it that I own up that I'm a pinhead. Look, you all can kick my ass. Even the smallest lady cop in the room, I get it. You can kick my ass. Funny, haha. But guess what? In the courtroom, I can kick ass. And so do you want to kick ass in the courtroom, or do you want to come and suck? And then the last part of it is to let them know, and this is certainly true, is that I've seen a lot of very bad officer witnesses at trial, and I've seen some really good gangbangers come in and testify at trial and just have the jury wrapped around their finger. And so, that's what I like to leave with is like, this class is going to be about how you don't come to court and suck. And I just can tell you I've tried the same approach with prosecutors, and you get really bad reviews when you open up a class calling them out like that.
I think it's the gangbanger thing is funny because, like, even though a lot of people might also want to be a SWAT guy, I think a lot of people also want to be a gangster. So
everybody wants to be gangster till it's time to do gangster shit, right?
Right. And at court, it's like, well, you could say whatever you want. You're like a movie star to them, to a jury.
Can you please cue that song from Office Space? Wouldn't it? What's the song? Wouldn't it be great?
Damn, it feels good to be a
Yes.
gangster. That's awesome. It's funny that, and this is part of the inspiration for this. And you guys know we recently had Judge Leon from California, and we talked about cops sucking on the stand. And it's funny that so many cops don't look forward to court. I think it's entertaining. I mean, obviously I talk a lot. That's why I started a podcast. And so I don't have a problem getting up there and talking. And I don't know. To me, it's like a sparring match, and I'm always down for a good sparring match when I know, like Josh is saying, that I've got the truth on my side.
Right.
I know the guy was drunk, so bring it on. Like, let's go talk about how I know he's drunk. And you can come at me with whatever you want all day long. And I just think it's funny personally.
Right.
But
Right.
so what are some of the myths and misconceptions that cops screw up when they go to court?
Well, and I think Jonathan will probably cover this as well, but just answer the question. That's a big one. Don't just answer the question. That's it. Just you go up there, just answer the question.
You're saying that's not good advice.
No, because then what you end up with is an officer who gets up there and looks like a robot, and it becomes a very artificial thing. And it's an officer it's somebody who's sitting there, and it's uncomfortable, right? It can be an uncomfortable setting. You're sitting in a chair. There's a bunch of people there. There's the jury there. There's the prosecutor. There's the defense attorney. There's the judge. And if that's the mentality that you go into, okay, I just answer the question. I'm waiting for that question. I'm just going to answer it. It's very robotic. It's very artificial, and you're not communicating effectively. What I would say you're there to do is you're there to explain what you did, what you experienced, and what you know to be true to the jury. And I think from the very beginning, from your posture, from the way you position yourself in the chair, to the way that you speak and the way that you communicate while you're on the stand, all throughout, that all changes if you're there to communicate with a group of people. You're there to explain to them and by the way, they think your job is pretty cool. Like I've tried new officers who go up there and are really, really nervous. If they're waiting outside the courtroom, and sometimes we're all lined up on the benches waiting to testify, I've told them, look, you need to know, and even crime scene specialists, our CSI folks that testify, they don't testify often, and so sometimes the newer ones get really nervous. I've told them, look, you may not realize this, but they think your job is really cool.
Awesome. Yeah.
They're going to be really interested in what you have to say.
Real life CSI.
Exact, right?
Heck yeah.
And so they have the opportunity to go up there and introduce themselves as a person and talk to a group of people as a person. As far as the positioning up there, when I get up on the stand, I move my chair. I face it to where I'm facing the jury. My chair is facing the jury. I'm sitting, I'm looking at them. I'm making eye contact with them. And this is my chance to explain, this is who I am. This is what my job is. And on this particular day and time, this was the investigation that I was called to come out and help conduct. And so this is what I did. And if you look at it like you're there to explain something to a group of people, you're going to be a much more effective communicator than if you're up there just, all right, all I'm doing is answering the questions. And you're sitting there like a robot.
It's not that simple sometimes, is what I've found. Like, to do it in a way that's compelling, like you're saying, it's not always that simple to just yes or no everything your way through it. And I've seen a lot of prosecutors ask questions of cops, and they're giving them an opening to explain, and they just go, yes. And you're like, and can you tell us more about that?
Right.
Yeah, I mean, direct examination is what we're doing when a prosecutor calls a police officer to the stand. And in direct examination, you can't lead. So you actually can't ask any question that suggests the answer. You can ask yes or no, but you really should be asking more about what happened next, and then tell us about this, and then where did you go, and why did you do that, and then what did you see? You know, that we really have a minimal role in direct examination. We're a facilitator of the police officer on the stand, which is why you must wonder about the intelligence of prosecutors who think it's good advice to say, just answer the question, because Josh is right. They get that instruction. And then we all wonder, well, why were they so robotic? Because you told them to be like that. So instead, I just feel we jumped ahead a little bit. Gosh,
we have tangents. That's what we do. I'm still waiting for hour one, the amount the DNA costs and how long it takes.
Patience, sir. So we skipped ahead only insofar as you got to start out by saying, look, the best witness is going to be the one who on that given day wants nothing more than to be in that chair answering questions about their work, whether it was all they did is check shoes into evidence or whether they conducted the entire, crime scene processing. Whatever you did, you need to be wanting to be there to talk about it. And that starts with preparation, right? And so I think there are people who are poorly prepared to take the witness stand because they don't know what's going to happen in terms of what Josh was talking about the communication that's going to happen. But the other thing that we see with witnesses and, frankly, prosecutors is if they don't do the really hard, like pick and shovel work of getting ready, then they're not going to be enjoying being on the stand. And when I say that, it means, you got to know your stuff inside and out to want to be there. So the way you do that is studying the report, looking at photographs, making sure you know everything that could possibly come up at trial. It makes it a lot more fun. You have to understand when Josh is talking about going to court, I've seen, 500 police officers testify at trial. I've never seen anybody better than Josh. Never anybody better. And it starts with the defense interview, which is a year sometimes before he's taken the stand. When Josh shows up at the defense interview, the defense lawyer slowly grasps that there is nothing that they will ask that Josh will not patiently and at length, if needed, answer. And that must strike fear into the heart of a defense lawyer who is going to rely on potentially confusion or they might themselves want to delay things. And all of a sudden, they're finding themselves at an interview in my office where it's 3:30 in the afternoon, and it appears that this crazy detective might go till 7 if they keep asking questions. And I just love to watch it. And that's the foundation for what he does at trial, which is that level of commitment to the work.
I have to come watch Josh testify in a case that I'm not involved with sometime, so I could get.
What do you wear to
in
court,
on that.
Josh? Might be a silly question.
I broke down. I do the suit. I wear the suit.
He's all in.
Do you have a jacket? I don't remember a jacket.
I do. I initially, when I was in narcotics, we did shirt and tie, and that was it. When I came over, I started doing the jacket, and there's no turning back.
Jonathan, if you notice a pattern in how cops are regarded by juries based on what they wear or anything like that?
No. I think that, when people ask me, I try to encourage them to wear what they think they want to be in. I don't have a preference of uniform versus tie or not. The problem you can run into with uniformed officers is if they get too robotic or paramilitary or cold. The thing is this is part of the trial class that we do is, hey, guess what? We're engaged down in the courthouse in a communication exercise, teaching. It's learning for the jurors with 12 people. Usually in my case, it's 12. It can be 8 in other cases in Arizona, but 8 or 12 people who have vastly different personalities. So one of them may really love an officer in uniform and one may be put off by it at first. So what we have to get at is that the style of communication is acceptable and something that people can follow with different personality styles and learning styles, right? And so that's where we run up against a problem with cops because they don't like talking about this stuff necessarily. I think you can get them excited about it, but they have to know that there's a tactical advantage to be gained from studying principles of communication, right? Because the way I describe it in the class is like, you ask a room full of cops, how many of you have ever taken an acting class? And you maybe get a hand. I mean, rarely. And then you say, well, do you guys realize that my closing argument, if you had Jake Gyllenhaal come in and do it, he would just absolutely crush it. We're engaged in something down in the court that has far more to do with communication of emotion and content and the truth of things than it has to do with the logic and the rational of just, the points A through Z. You've got to be able to make jurors believe that you've given them the evidence. And to do that, they have to be able to feel that from you. So the uniform, I think, or answer the question yes or no, or whether you wear a tie, really distracts us from what has to happen, which is you got to have a person who wants to speak into the microphone, look at a bunch of people, and talk to them about what they went through. And it could be funny. It's not like we're asking for tears. We're asking for truth. It might be laughter. So I've had a SWAT officer on the stand in Flagstaff who, in a murder case of a 16-year-old, you'd think everyone is just totally serious all the time, but we're in that courthouse for 5 weeks in that trial. And when he first started talking, he talked about, they always make me go up front in SWAT deployments because I'm the shortest one so everyone could see over my head. And he just said it in a way. It's like everyone laughed and it made him human.
Not lying.
There's a book by a famous defense attorney named Jerry Spence, and the book is called Win Your Case. And it kind of goes into this about how to be charismatic and how to de-robot a little bit. It's intended mostly for defense attorneys and people who want the skills that defense attorneys are known for. I recommend it. We'll post a link in the show notes to it. It's Jerry Spence, Win Your Case. Might be worth checking out.
There's, I used to do the shirt and tie thing when I was going to court for stuff, just, my own car. And then when I got in a canine and I had a take-home car, and then the dog would usually come with me because inevitably on my way home, there'd be a call for a dog or something like that. So I ended up taking my patrol car to court with the dog in the back more often than not. And so I found myself in uniform more and more. And the way I thought of that is hey, just recognize exactly the things that Jonathan is saying, that, you don't want to be robotic. And I would like to think that I never have been. I'm into the public speaking thing. I like to teach. And so I like to talk. You can get me talking, and it's usually someone's going to have to shut me up. Someone's going to object or whatever. And so it's all good. But I always make a point of I'm in uniform and I want to personify myself as best I can. So like Josh said, I always try to look and address the jury, and I always try to smile at them and just be likable. And I think that another thing you said, Josh, about, hey, they think your job is really cool. They want to hear about the dog. They want to hear about the SWAT stuff.
Absolutely.
Or even, the patrol stuff and the investigation. They want to hear about all that stuff. Most of those juries in a DUI investigation, they don't know anything about what the thing is when you wave the pen in front of people's eyes. They want to learn about that test because it's interesting to them. If you can do it in an interesting way.
What's fascinating about that is there again, we prosecutors do you guys a disservice, because one of the things I was taught is tell police officers you don't want cop speak. And it took me a long time to realize, no, that's not true. You want it, you just need to then clarify it. So if you're going to say you guys have a code for everything, so it's I was 10-2 at the 586 or whatever. And it's that's great. That's exactly when you say
you
that.
Nailed it, actually.
That's right.
But there's a reason we're all watching TV shows about what you do. Yeah. It's fascinating to people. So if you say I was 10-2 at the 586, then I just say, hey, can you tell, you guys have a code for, what does that mean, And if you can do it yourself and just stop and catch yourself and explain, that just means I was on the scene with my dog or whatever.
Right. Yep. If you guys didn't catch it, if Tac Tangents is the Cops or Live PD, this is the Law and Order edition.
Should we talk about DNA?
I would love to talk about DNA.
Jim's getting a little antsy.
There's a reason I'm asking, right? Is because there's a expectation among the citizenry that we just have all these incredible resources, and how come all the rape kits haven't been tested yet? That was a big issue where I was last stationed in New Mexico. There were 20 million rape kits that have never actually gone to test. Can you speak to kind of the expectation management that maybe society should have about that?
Well, we're thrilled, by the way. We got a grant to test all the rape kits in Tucson. Yeah. There isn't a backlog now. And in fact, we got a follow-on grant to follow up with additional investigation. So that's exciting. And so I don't want to, diminish the need to test sex assault kits. But in the larger sense of things, I am in the position as a prosecutor of having to put on evidence in every case about forensics. And so I think it's hilarious. Newer prosecutors or ones who maybe aren't paying attention, who have been doing this a while, they'll say, why would I call the DNA expert? I didn't get any results. Well, you better call the DNA expert to explain why you might not get results. I actually...
Why is that so hard? Imagine that.
Having tried some huge, difficult, cold case murders that were circumstantial in nature, I now start... I don't even wait for opening statement to deal with this issue. I start in jury selection by raising the issue of how many of you think circumstantial evidence is worse than direct evidence? And I mean, everybody raises their hand. What are you kidding? Of course, circumstantial evidence is way worse than direct evidence. Just sounds worse, right? And then I say, will you be able to follow the judge's instruction if the judge tells you that DNA evidence, fingerprint evidence, forensic evidence, firearm tool mark evidence is all circumstantial evidence? And that direct evidence is just what a witness saw or heard. Will you be able to follow that instruction? Does that surprise anybody? People are shocked when they hear that. Okay. And so we start in jury selection. I like to address exactly what you're getting at, which is that the attitude of most people is that we will solve every case with forensic evidence, usually DNA. And the fact is that you can swab sometimes even so there's a alarming thing that happens in sex assaults is that the often male perpetrator will often bite the female victim. I know it's not always, it could be a male on male or whatever, but that
bulk
bite mark
of them ends up that way, right?
And that bite mark can be swabbed and should be, because saliva is a rich source of DNA. So when you swab a person, a sex assault victim, swab a bite mark on them, you're looking for the assailant's DNA. But you should see the jurors and the shock in their eyes when you call the DNA expert and have them talk about the fact that they have personally experienced swabbing the victim and not only not getting the male profile, but not getting the female profile. So now jurors understand, because before we have this discussion, there will be people in the jury box who literally believe I walk around and I'm just sloughing off DNA and you can just follow a trail if you
Every
have the
contact
right...
leaves a trace. I learned that on CSI or NCIS or one of them. Yeah.
So we've got to really adjust these expectations. And the way we do it is by presenting the truth through the scientists who do the work so that we can adjust, people's expectations.
Yeah, and then as a witness, as an investigator, when I get up on the stand and I'm explaining the decisions, the investigative decisions that I've made in a case in regards to what I ask the lab to test for, I think it's important. I think far too often I've seen other investigators and other officers say, well, it's just not feasible. Can't test everything. It's too much money. It's time, backlog, and all those are... I get that there's some legitimacy to that. I mean, our lab is not capable of testing every item in every case, and there are backlogs, and there are other cases, and and these things cost money. But in reality, what I like to focus on is, look, I decide what items I'm going to ask the lab to conduct forensic testing on, and I do that, in such a way because I want to help the jury understand what happened. I need to understand what happened. I need to help the jury understand what happened. What interaction was there between the suspect and the victim in this case? What evidence is there that can help me understand that? And if I were to go through and have DNA testing done on every item in every case, that would be problematic because I would inevitably come up with potentially DNA profiles for people who had nothing to do with this case. There may be items of evidence that we take and that we later on determine, well, actually, this incident didn't happen over here in the west parking lot. It actually happened over in the east parking lot. But if I decide, well, nope, I took this stuff, I'm going to have everything tested, anything that's over here where the incident didn't happen, that can take us backwards from figuring out the truth, from learning the truth, and from understanding what happened.
This is something that I I should start copywriting this stuff. I don't know. I feel like Josh and I came up with that in a case way back when. But
I was on Tactical Tangents. We're calling it.
There is a serious problem with the potential for implicating an innocent person if what you are going to do is test evidence that had nothing to do with the crime. And I feel like if we start explaining that better to jurors, they will stop demanding. Picture a Circle K, a horrific attack, and the clerk is shot or whatever, and the robber touches the cash register and the counter. You would never go over to the Doritos and one aisle over and start swabbing them. You might get the person who was in there the day before, thinking about whether they wanted Cool Ranch or whatever taco. Do they still have taco flavor?
Nacho cheese.
Do you remember taco flavor?
I like the salsa verde personally. Yeah. That's my thing. That's my jam. But
so on the topic of the forensics and we talked about the sexual assault nurse examiner rape kits. We did an episode about sexual assault a couple months ago, and I was a peer counselor in a college environment. I dealt with a series of acquaintance rapes where the victim knew her attacker, and it was almost always a female victim in the cases I dealt with. And one of the things that I saw in the problems with prosecuting was the presence of DNA or absence of DNA was irrelevant to it in a lot of cases. And it was really and I hate to use the phrase, he said, she said sort of thing, where she was drunk and unable to consent. The alleged perpetrator was drunk and effectively unable to consent. And it made it incredibly hard to actually prosecute. Can you speak to that? And is there any way to resolve that as a society or anything like that? And whichever direction you want to go with it. But I just want to pick your brain about it.
Wow. Well, that's a tough topic. Alcohol-facilitated sexual assault occurs all too frequently. It's there are cases where if we can establish that no reasonable person would have interpreted, like for example, unconsciousness is clearly not consent, right? So that makes a case pretty triable if we can get there. Some of those cases, you're right, can be extremely difficult to prevail on at trial. So I don't know how else you get at that problem other than awareness. I think we've gotten really good. April, it's May now, but just a few days ago it was April, and April was Sex Assault Awareness Month, yep. and we did some work to let people know that the key is to get consent. I think we've gotten a lot better about this as a society to talk about, the need for consent, and people are becoming aware of issues around alcohol-facilitated sexual assault from books like Krakauer wrote a book about issues out of Montana, I believe, with a failure to prosecute some of these cases that involved, I think, some football players up there. So
interesting.
Look, I don't have all the answers, but I do know public awareness is super important. And, Special Victims Unit prosecutors in our office deal with domestic violence cases, which are some of the most difficult. And then these types of cases that you're talking about are also extremely difficult. And you're right that you're not going to solve them all with DNA.
And on that happy note, you mentioned the domestic violence, and I've noticed a pattern, particularly with domestic violence, but in a lot of other cases of violent criminal recidivism, where a guy is getting arrested for beating his spouse over and over and over, it seems. And certainly when I was in New Mexico, it was really, really bad. Guys would the people who murdered my gas station attendant, which happened, many of them had up to 7 violent criminal cases in their background, and they were still out walking among us. Is there anything you can speak to as far as what we can do about violent criminal recidivism?
Well, I think that's been my focus as a prosecutor. That's more than anything else is making sure that we target repeat violent offenders. That's where the bulk of police and prosecution efforts need to go, is keeping people safe. And I think we've been distracting ourselves personally, and I'd love to argue with you guys about this. We've been distracting ourselves with a war on drugs that is premised on some flawed ideas. And And now I'm going to just throw down a gauntlet because I know cops, I don't want to stereotype, right? But police officers, probably more than most, didn't smoke a lot of weed growing up and don't mind throwing back a few alcoholic beverages. And that, I got to be honest, bugs me. You guys must notice that there's way more mayhem that results from alcohol than pot. And so the fact that we have very scarce resources to patrol our streets and put away people who threaten the safety of others. So let's use the resources wisely to do just that. I don't know. I can't speak to your example in New Mexico, the convenience store clerk. That sounds like a tragic case. What I can say is we can't guess right 100% of the time. And so sometimes somebody will appear on our radar as a low-level offender. Josh and I handled somebody like this. He was showing up as a low-level offender until he murdered a 62-year-old woman who was disabled from childhood polio. And, I guarantee if we had sought to send him away for a lengthy prison sentence before that murder, people would have said, see, it's just police and prosecutors run amok trying to grind this guy down. He's just a low-level offender. So, part of our job, that's what I mean when I put up that slide and you got people yelling in both ears. It's like our job is tough because everyone every day is accusing us of being both too weak and too strong. Every day, that's our lives as cops or prosecutors. But when it comes to repetitive violent offenses, send a few my way, my friend. We know how to deal with them in Tucson, Arizona.
It's interesting, the drug policy debate in the United States is probably bigger than Tactical Tangents, anything that we're going to resolve tonight. My understanding is that in most of the southwestern United States, if you get caught with a joint, you're going to get like a $60 ticket and go on your way. I don't think most people are going to jail over that, right?
Here's at least this is my perspective is like if I find a guy with a joint, I'm like annoyed that I even have to deal with that personally. That's just Mike talking, right? No agency position, but like, that being said, I think the war on drugs thing is an interesting topic because I agree. If there is a way that we can take the emphasis off of that and just focus on all the things that people who are addicted or whatever are doing, like that would be golden. Like if we can deal with all the auto theft and the burglary and the home invasions and all those things without having to worry so much about the drug possession stuff. I mean, that would be, like you said, Jim, a tough nut to crack. That's probably its own episode at the very least. But
we should maybe we should do a roundtable about that, about what we should be doing policy wise. But one immediate follow up that I can think of is how much of that can be resolved through police discretion and prosecutorial discretion. Like, hey, we're just not going to deal with this right now.
We kind of got that going.
How much of that needs to be resolved at the state statute level?
Well, so one thing you ought to know about what we're doing in Pima County, which is really exciting, is look, the problem with police. I mean, think about it. You got a dog, you got a gun, you got a taser. You're ready to protect the community from danger, and instead you're picking up somebody who's got a small amount of heroin in the park. All right, that is a public health problem, and now we've gotten very, very good here in Tucson at creating programs where we can get somebody. We're about to build a program called pre-charge diversion, and what this means is you could be arrested for heroin in the park, and you could be given a court date where you appear in front of a judge who's specially trained, and that court actually is filled with treatment providers, not just for substance use disorder, but also for mental illness, for providing housing for the homeless, because none of us want a degradation of our community. But if our only answer is to send out the SWAT team, we are really barking up the wrong tree, right? I mean, and if our only response is, well, we'll either put you in jail or prison where you will get zero drug rehabilitation or treatment programming, then what do we think is going to happen when you get out? You're going to go right back to it. So I'm an alcoholic addict. I've been sober for almost 19 years. You can't fool me about this stuff. I think relatively well, I don't know. I don't want to judge. I feel like I run across relatively few cops who are fellow alcoholic addicts. But if you know what it's like to wake up in the morning and be like, holy crap, today I really have to stay sober and not be able to like make it to the shower without using. Okay, if you know that feeling and live in that way for years, then I think you understand that putting somebody with that disease in prison is a really inefficient thing to do. So we've got programs, they're better. They will free you guys up to do what you want to be doing. And I think the other thing that really leaves me dry is when people say, well, you know, this heroin addict in the park, sure, they only had a little bit of heroin today, but I know they were breaking into houses. How do you think they could afford the heroin? It's like, well, okay, go catch them breaking into a house and then we'll prosecute that, because I do not mean to suggest that drug addiction is a get out of jail free card for any kind of offense. I'm just suggesting we should not be tying up police resources for crimes that are threatening the community in order to deal with the public health problem.
Yeah, and locally, I forgot to even mention that because frankly, I don't deal with it as much in my assignment now. But we do have like a deflection program where now officers have the option of taking someone to treatment instead of arresting them, and so those things are in place. And it's interesting how resistant a lot of cops are to those sorts of things, and I'm not sure I understand why. I think a lot of it is just a lack of understanding or critical thinking, which is why I've wanted to address it on the podcast somehow, but we definitely need to tease that one out. So if you're ever up for coming back, we could try to tackle that in and of itself.
I would highly recommend getting Amelia Kramer. You mentioned she's the chief deputy at the county attorney's office, and she's the person in Arizona who knows more about building treatment alternatives to prison than any other person in the state, and one of the leaders nationally.
That would be awesome.
Yeah, we could dive pretty deep with Amelia here. We've both been working on these programs. Sorry to take us off course, though.
No, it's interesting, and it has tactical implications because so much of the violence that we see across the country is drug-related, right? We've got crime involving the cartels and the drug trade and drug traffickers, and I believe that there was didn't you guys find a Somali out in the middle of the desert with body armor and an AK-47 with his head cut off or something like that? Like, you know, there's some real legit violence happening, but like, you know, I have this picture in my head from Sicario, right? Of the magnitude of violence happening. And so like, you got that on one side. On the other side, you have, you know, we don't need to be rolling up every dude who, you know, shoots up in the park. So I don't know. I don't have a solution to it, but I think it's interesting and it does have tactical implications.
And here's the thing is that I think, and if for a lot of the cops that might be listening to this, and you know, we generally avoid to get too much into politics and policy and stuff, but like Jim is saying, I think this has very specific implications for a lot of the work that we do. I mean, yeah, there's a good portion of the SWAT operations that I've been on that are absolutely related to narcotic sales, but I can tell you that the ones that are the most significant to me that I take a degree of pride in dealing with are those violent offenders. And those are the guys that are out doing the robberies and they're tying people up and beating them and torturing them. And that has happened. And so what I want cops to hear from this little tangent that we took is just to be open-minded and understand that there's another...
there are strategies that can resolve your tactical situation.
Yeah, there's a narrative to it, and I acknowledge it's a complex issue. It's not something that I think that just like, oh, we should just make drugs legal, and okay, well, I don't know that it's that simple. But
well, and to be clear, I would 100% agree. I want to see resources going to fighting drug trafficking, and that is why we have to be smarter. So let's talk about the supply side. We're all down for the fight against the supply side for all the reasons we just mentioned in terms of the violence. And peddling poisons that are killing. I mean, in 2017, 70,000 Americans died of drug overdose from opiates. I mean, that's more than died in Vietnam, folks. I mean, so yeah, we need to fight the supply side battles. I just think we have to be careful whenever we think we're being, you know, and I want to use air quotes, tough on crime, because I'm more excited about being smart on crime. I mean, let's end crime. Shall we all agree on this? It'd be nice.
Yay.
And you know, when we talk about personal possession of small amounts of narcotic drugs, we have an extremely expensive and extremely ineffective instrument called prison that we've been using as a last-ditch resort, and we've developed better methods that have more to do with combating addiction. And so I don't get it when police officers say, "Hey, I've been hearing what you're saying, and you're against you're pro-drugs." No, like, I'm talking about combating addiction effectively. And I'm really excited because I've been able to, once I have conversations with people who have really been working in narcotics and have expertise on it, they're all in on what I'm talking about. So it's about being effective against drug addiction and then continuing our fight on the supply side.
Are you guys seeing a trend as far as the drug use in your area? Like, are you going toward fentanyl real hard or going toward meth real hard or anything like that? Is there a veer anywhere in your stats?
Fentanyl.
Yeah, meth has been here. Meth has been here, and we're seeing it. I think it's cheaper now. I haven't worked narcotics in quite some time. I worked narcotics for a long time, but meth is still here. It's pretty prevalent. Fentanyl, we've seen a big increase in the amount of fentanyl, particularly in pills that appear to be prescription pills, but I think they're coming over from across the border, and sometimes they contain fentanyl, sometimes they contain higher levels of fentanyl. We've seen cases where people are utilizing the dark web to order up pills or substances, and it runs the gamut. You don't know what could be potentially in these pills, but fentanyl is definitely a huge problem.
They're counterfeit. They're counterfeit pain pills. And what is actually in them is fentanyl.
Interesting. Between the two of you, we have substantial professional exposure to all kinds of criminal, the spectrum of criminal cases and criminal prosecution. Do you guys have any insights that we can glean about how potential victims can protect themselves better, right? How they can manage their risk and not get their car stolen, not get their house broken into? Is there anything over the course of your career where you're like, man, I wish everybody in Arizona understood this thing about protecting themselves?
I don't know if there's one thing. I think that being aware of your surroundings is really important. I think that's a big thing. If I were to bring it down to one common denominator, be aware of your surroundings. If you're driving a brand new truck or a brand new Jeep or something like that, something that's in high demand, hey, lock your doors, use a club. If you're leaving a grocery store or somewhere and you're in a parking lot and maybe the lighting's not that great, be aware, stand up, look around, make sure that everybody sees that you are paying attention to what's going on around you. And that way, if something does start to happen, you're aware and you can react to that maybe a little bit better. Or if there is somebody who's predatory out there and they're looking to find a victim, maybe they're going to choose somebody who's maybe a better victim, somebody who's not paying attention, somebody who's distracted. I mean, I think the one thing that I would say is be aware of your surroundings, walk with purpose, pay attention, look around. That'd be my recommendation.
Yeah, I was going to say situational awareness. I was just thinking back to a couple episodes in my own life where, sitting at a traffic light in the middle of the night in Phoenix when I used to live up there, and some people started approaching the car and I just took off. I didn't care if it was red light or whatever, or in Chicago one time when I guess I like to skedaddle.
Don't be there. Avoidance is the best counter tactic. That's literally in my tactics manuals for flying airplanes. Speaking of that, Jonathan, I assume you have been threatened in the course of your career. Have you ever felt threatened by some of these guys you're going after in the course of your career? And has that affected how you do business or how you live your life?
My wife would say that I have a focus on a secure perimeter at the house, which she does. I can't wait till I can save up money and get bars on the windows and stuff. I worry about it a little bit, mostly I just want to make sure she's safe and things. I certainly make sure at home that in a safe way that we're armed in the house and stuff. We have dogs. Yeah, there's some scary people, but what you realize when you do this for a while, I bet Josh has the same perception, is that probably it's not the ones that you would think. It's like somebody mad about a misdemeanor or something. It's like,
Yep.
yeah, who knows what drives people? So you just got to live your life. And yeah, my wife is good at just reminding me of that, of the fact that you just got to enjoy life and not be peeking out the windows, because I'll be looking at, hey, what's that? I just did this last weekend. What's that truck doing there? Well, I don't, don't worry about the truck. We're eating dinner.
Amazon package, probably.
You do get a little. I'm curious. You guys probably are. All three of you know more about this than I do. Is that? But you get a little warped in this line of work to where you see such bad stuff all the time. How do you not let it affect you? It's a big challenge.
Yeah, I think there's a fine line between being aware of your surroundings and taking precautions and letting kind of hypervigilance or paranoia even control you and take over your life. And at some point you have to live your life, and you can do that safely, and you can do that by paying attention and taking, common sense precautions, but you can't let it, if you let it take over and control your life, you're not living your life, and that doesn't work.
I had a friend, may he rest in peace. His name is Dr. Stephen Pitt. He's, in my opinion, the best forensic psychiatrist in the country. I only got to work with him on one case because he's so expensive. He really, it cost a lot, but he's absolutely the best. You would have loved working with him, Josh.
Yeah.
And he was murdered out in front of his office a couple years ago. I was actually in the Miranda road rage case, getting ready to do the closing argument when I found out he had been murdered. And, here was a guy, forensic psychiatrist in a criminal setting. Okay, so he dealt with like the scariest people you could think of. But the one who came after him was somebody from a divorce where he had done some assessment of this guy years ago. And,
Yeah, you're right. It's not I've done this job a long time, and I've testified in a lot of trials, and I've worked a lot of cases as a detective, and had a lot of people who are in prison as a result of that. But some of the people who have been the most vocal against me and the angriest against me have been actually some of the towards the end of my time at the Counter Narcotics Alliance at CNA. I was when I was a narcotics detective, we were tasked with going out and working these illegal marijuana grows that were happening at people's homes. And man, we didn't want to deal with those as it was, because we had a medical marijuana law that was here. And so it was it was a gray area in a lot of people's minds, even if it wasn't necessarily a gray area by the law books. But it wasn't something we were interested in dealing with, but we had to go out and deal with it when those calls came up. And man, you take away people's plants, they get so angry. There are people who, to this day, my name is popping up. This is 7 years ago.
Do you give them like a hand receipt for their plants?
Oh man, my name comes up online from these people who are still angry about these plants that we took from them 7 years ago, and I'm like, I didn't even want to be there, but I got called and told to come out, and I did what I did, and people got probation, but they're furious.
But that was the best strain of Indonesian or whatever.
I mean, and I liked talking to there was a guy. There's some really, not just anybody can grow marijuana effectively. Like it's like just like not just anybody can have a really nice garden at their house.
There are whole podcasts
it takes talent. Right. It takes talent. It takes skill, and it takes a lot of knowledge. I enjoyed talking to the people who are really good at it. There was a lot to learn from those guys. Yeah. I really liked that aspect of it.
No wonder you took a trip to Humboldt County.
I did. I did take a trip to Humboldt County. Not for that, but
Josh is taking notes for retirement.
No, but I liked that. I thought. I mean, there was a lot that I was able to learn from some of those people. They were really, really sharp people, really smart people, and they just went about things the wrong way. Like had they waited and worked as a dispensary agent, maybe they'd be millionaires, but they didn't for whatever reason.
Yeah, there's some big money there for sure.
There's a ton of money there. Yeah.
Especially right now.
Yeah, absolutely.
I think even if you're super duper anti-drug of all forms, the way the federal schedule system is structured is asinine and drops the credibility of the whole federal law by saying that marijuana is Schedule 1, which is a more serious category than heroin.
It's silly.
It's mind-boggling, and it weakens the whole drug law system when we have it structured like that. So that's my little editorial on it.
It makes it difficult for us to get to the actual discussion that we need to have, because that's going to be the first thing that everyone throws in your face.
I just love talking about it though, because I'm so fascinated because I'm almost 19 years sober, right? And so I watch, and it's like, we got some really good bottles of scotch sitting over there. That used to be my thing, right? And so I'm trying to read them like,
but I don't want
18-year.
I want
Josh,
6.
can you pass the... And the thing is that with the way I was drinking, every now and then, like I couldn't predict when it would happen, but I've woken up like strapped into hospital beds and stuff, and you can die acutely from drinking alcohol. And I challenge you to sit down and smoke enough weed to kill yourself, like acutely. It just can't be done. And so, people are dying in large numbers on the freeways because of alcohol. And so I just don't get somebody pounding the beers and telling me about the evils of pot. It's just a weird thing we have in our society. Watch the movie Platoon. It's the best study of this that I've seen.
The one thing I will have to say, though, is that marijuana DUIs is definitely still a thing.
Absolutely.
I've seen some bad DUIs. Like, the driving is horrible.
Really?
Horrible.
And look, so here's the thing. It's not healthy. I gave it up, okay? So I'm not promoting drugs, especially illegal drugs, but marijuana is not health food. We need to keep it out of the hands of kids. They have developing brains. It can affect them differently. We got to keep the roadways safe. We need people to be sober on the roadway. But I'll ask you this, Mike. You have a choice. You're going to drive out this door, and you're going to leave your house, and you're going to confront an intoxicated driver. Do you want them to have smoked pot or gotten drunk?
Easily weed.
Yeah.
Yeah, they're 100% more. I wish we had a running tally of the number of problems that we run into, like responding to just general 911 calls throughout a shift. The percentage of them are that are drunk, whether it's domestic violence, whether it's the fight, whether it's
docile versus hostile might be a good way to describe it.
Yeah. Stuff like that. So.
Yeah.
I used to have to go on an apology tour in the mornings, boy. After I had a propensity to headbutt people, and I could never back up any headbutting behavior. It's
just your thing,
yeah.
Trademark.
So I'm going to have to head out soon. I've got another commitment that I have to get to. I'm sorry about that. Speaking of your origin story, you're obviously a very successful attorney. Otherwise, you wouldn't be in the position you're in right now. Can you talk to us, if I want to become a prosecutor someday, what path should I take, and what path did you take?
Great question. If you want to be a prosecutor someday, the best thing to do, and I tell this to everybody who's going off to law school, because for me, undergrad, you can get away with a little more in undergrad. But in law school, things start to become very real as far as you're going to close doors on yourself in terms of opportunities if you don't get really solid grades in law school. So I think work your butt off when you're in law school and remain open to the different possibilities, because you might want to explore some other areas of practice to make sure that that's what you want to do. You can foray into other areas, and we're still going to welcome you in prosecution because we tend to have a need that just isn't going away. I wish we could solve it in terms of, the
supply
types
side
of work
versus
we
demand
do.
side problem.
Yeah.
See what you did there.
Yeah. So it's a matter of whether you can put up with the relatively low pay and still pretty demanding hours to do the job right. But what other type of law can be this interesting? It's just people who work in DA's offices tend to talk about it as the best job they ever had as a lawyer, if they ever leave.
That's legit. So Jim, you got to take off?
Yeah, I'm sorry, guys. I'm heading out the door pretty soon, so I've got to attend to the family, that sort of thing. So thank you for your time. I've learned a lot from you, and sorry, I got to run. Cheers.
All right, guys, so Jim had to take off, and we're going to continue this conversation. I'm going to try to circle us back to some lessons about going to court for those of us that are still listening for that original topic that we started with. Can you guys talk to us a little bit about the difference between probable cause to arrest and reasonable doubt to get a conviction?
Sure. And, oftentimes we'll run into a case where we're gathering the evidence and, yeah, there may be probable cause to make an arrest, but you have to make a determination. Look, is this something to where I need to make this arrest right now, given the facts and circumstances surrounding the entire incident? Or is this something where I collect this information, I gather the evidence, I put my investigation together, and then I present this to the county attorney's office as kind of in a non-arrest format? Is this, how do we feel about whether or not this is a trial case or whether this is something, do I need to make the arrest? We've seen this, there's a case that I'm working right now in regards to that. It's a homicide, but there's definitely some potential self-defense issues related to it. And then on the other side, there's some potential felony murder aspect to the other players on the other side of this, these two groups of people who kind of had an interaction over a very small amount of drugs.
Weird.
Yeah,
we're back there again.
Right. So we do run into those cases, and I think you have to look at it like, look, is this a case where do we have to arrest somebody right now? I mean, yeah, this is a homicide technically, right? But there is a very strong possibility that the person who is the shooter in this case is acted in self-defense, or at least a great possibility that happened. And so we need to weigh, okay, is it dangerous not to make an arrest right now? Or is it, or am I doing the wrong thing by making an arrest right now, given the fact that, no, there's a pretty compelling argument to be made that this person acted in self-defense. And I think we have to look at those on a case-by-case basis. And if we can determine, look, I don't see the danger in not making an arrest right now. I don't think it would be appropriate to arrest this person given the facts and given the evidence as I understand it right now. You have to be able to say, look, this is a case where we're gonna long form this, and we're gonna put this case together, and we're gonna present it to the county attorney's office, and we'll see what the charging decision ultimately gets made, or if it's going to be a declination, a prosecutorial declination in respect to the homicide charges.
So, Jonathan, how do you fill that gap? So if let's say at whatever point you guys reach that decision where we're going to make the arrest, we have what we need. I mean, there's still that gap at trial potentially, right? That you have to kind of close.
Well, and let's flip that around, because every now and then, and it's happened to me 3 times in my career, where we actually, in the course of the case, uncover facts that cause me to believe we have the wrong person or the crime did not occur. So I remember one case where a young lady was accusing her stepfather of having molested her, but facts emerged relating to her desire to not have a change in her living circumstances, which, there are actually experts who work in this field who will say that the most common areas where we see, because there are situations where victims have reported crimes and it turns out not to be true. So what? In our profession, I appreciate that, because I want you to know, there's look, I want to fight sexual assault. That's what I do. I want to fight child molestation. That's what I do, or violence of all kinds. But every now and then, we uncover facts that tell us that a victim has lied. And it's incumbent upon us, police and prosecutors, to make sure we don't try to auger down and prove that case. So our job, this is why it was such a big deal that Josh opened by saying our job is to present the truth. We really have to believe it when the going gets rough in our case. And there's all kinds of reasons why that's difficult for human beings. You've gotten invested in it. You've started to look at it in a certain way. You've started to convince yourself, and to be able to realize, like, hang on, I have a bias here, but there's some information coming at me that shows that I'm incorrect. When I say that, I mean a bias, like a confirmation bias.
Right.
I don't mean like a racial bias or anything.
You're unintentionally cherry picking facts that make it seem like you have the right guy, when there's other stuff you're just completely subconsciously ignoring that suggest otherwise.
Yeah. So I'm proud of having dropped cases when the evidence did not go the way that we thought it would. And so that's not what you're trying to get at, because that's been 3 cases out of all the cases that I've handled. So far more often, you're figuring out how to present the strongest possible case and marshal the evidence. And when Josh first brings in his investigation, well, Josh is good, so it's largely complete. I mean, he's done a lot of work, but there's still going to be little things we've got to follow up on. Sometimes it's the rounding out of the story and the motives and the other tangential players and what they observed. Sometimes it's really amazing evidence that comes to light. I'm thinking of the Vail stepfather who killed his 13-year-old stepdaughter, and we were still getting like amazing evidence down the road because of computer forensics and the ability to get into iPhones or tablets. That takes time. So there's a lot of work to be done when the case comes in the door. It's in some ways it's only beginning then. But one thought is that on the other side of that case is a defense lawyer who's going to fight like heck to try to vindicate their client's interests. And you've got to be open to the fact that even if they haven't proved their client is innocent, they could be really taking away your ability to prove your case. And that happens far more frequently. I've had 3 cases where I had to drop them because it was unethical to proceed. But far more often, I have cases where the defense lawyer does a heck of a job, and it turns out it was a much more complicated story than we thought.
Yeah, and I think to answer that, my job as an investigator doesn't stop when I've brought that case to issuing and when I've taken that to grand jury. I know that some detectives believe, well, that's it. They've been, I got the indictment, it's on the prosecutor's office now. And that's not the case. I mean, my job continues. I should keep working the case and to its logical conclusion. I'm a big fan of investigative momentum. And that means you work a case until you've gotten to its logical conclusion. And, sometimes you've gotten to a point where you can take a break, and then I may need to go back and I may need to do more social media search warrants. I may need to do some search warrants for cell tower data records, CDRs for phones. I may need to do more interviews. I'm a big fan of the job's not complete until you've completed it. It's not complete just because you've made an arrest. There's always follow up that can be done, and it's just a matter of determining what follow up is reasonable and necessary, and doing that.
Yeah, I would imagine, and I not having been in your guys' shoes, but having been involved in the early parts of many, for example, homicide investigations, when you get there and you first start talking to people and you start to build your understanding of the story that starts early on, and then you've just got this framework that you slowly fill out as you interview one witness. You start to understand one thing, and then you interview another witness, and it starts to, okay, now I'm seeing why this person said that. It's not necessarily that they were lying. There's just parts of it that, and so over the course of what it starts as like a half a day or whatever investigation, and then continues on now maybe for weeks, you've put this together, and you're putting it together from the perspective of people who have done this hundreds of times or whatever. But that's different now to take to like 12 lay people, 12 normal everyday that have never necessarily done this sort of thing before. And like now you have to try to tell them in a story in a very linear, and I'm assuming that there's bits and pieces of that you have to decide, like, do I want to go down this path with the jury? Is there value in trying to talk about like this guy's background or his attitude or how he's dealt with other problems in the past? I don't know, just whatever little nuances that might contribute to the story in some way or another. Like, you've got to decide how much do you want to muddy the waters for a jury to make your points. I mean, is that the kind of decisions that you're making?
I mean, the thing that comes to my mind is, and let's put a copyright on this too, because people will be talking about this later without me.
All right, you guys heard it here first. Copyright Tag Tangents 2020.
Someday.
I'm just kidding.
So, I think prosecutors make the mistake. Let's take homicides. the way they present the case, if you go over and watch a bunch of homicide trials, you would think that the prosecutor was intent on proving that the killing occurred, that was what they had to do. And the reason I say that is because they'll call first the people who responded to the crime scene. And there's, that Josh and I made a decision in the Lelevere case, the Vale stepfather. And this is informed by a lot of trial work that I've done where I realized, no. See, I grew up watching Mike Tyson before he was an ear-biting crazy person, when he was like 18, 19, 20 years old, and he was scary in the ring. And it was like the first 90 seconds, every fight was over, right? And I realized that's really how you should prosecute a case. All of this cutesy nonsense about waiting to give the jury the DNA last so that they can go in the jury room and have it. I mean, we're trying a case that's a month long. You want these nice people to wait for your good evidence for a month. That's what we've come up with as prosecutors for a strategy. It's outrageous. So in Lelevere, we decided to do two things. Number one, we're going to race to get our best forensic evidence in. A lot of it was computer forensics in that particular case. We're in a race, like for the first 3-4 witnesses. And that the very first one, the thing we realized in that case is that if the jury did not believe that Jaden's mother killed her, which is absolutely preposterous, they would never believe it once they met her, then they were going to understand that her stepfather killed her. Those were the only options, really.
Right.
And so we called her mom first. And you see a lot of nonsense where she would have been, in most cases, called toward the end for the emotional impact on the jury as they go to the room. We didn't want to mess around with that. We wanted to go with our strongest, best stuff first.
That's interesting. It's funny how many tactics, in a sense, you guys have to deal with in trial settings, different than tactics out in policing. Policing still for Josh, but in a different way. It's fascinating. Josh, you have any stories about cases you took to them that didn't go your way?
Yeah, I can think of some trial scenarios and where things didn't work out the way I would have hoped. And I think it all boils down to a lack of communication between the prosecutor and myself, and a lack of preparation. I can think of one instance, both of these are from narcotics trials. I can think of one instance where I was going to testify, I was going to do expert testimony or give expert testimony in regards to drug sales and how those drug sales occur, and common practices of people who sell drugs under certain circumstances. And I had a prosecutor who I'd worked with before, and I think this was my second trial with him. The first time, didn't have any problems. Things went very well. The second time, he had made a decision to handle the direct testimony a certain way. And so he got up and said, "So, detective, tell me about modus operandi." I said, "Oh, well, that's how a particular way of doing something. That's how somebody commits a crime." And he looked at me like, "No, you're not helping me out here." And I wanted to call a timeout. Like, okay, hold on. You need to, let's
set that up better.
Let's do a do-over, right? Like, because if we had sat down and talked for 5 minutes prior to trial, and he had said, "Look, I'm gonna open up with modus operandi," I would have said, "Hold on. Let's talk about, like, what are you going to ask me? What testimony are we looking to cover here?" Because if I'm going to explain to the jury, look, this is how, in my experience, drug transactions occur on the street, in a vehicle, in a parking lot. This is where they happen. These are some reasons why people who sell drugs in parking lots, out of cars, operate the way that they do. Like if you ask me those kinds of questions, I can run with that. But the modus operandi thing, not helpful.
Have you, Mike, ever gone to court and testified without the prosecutor meeting with you beforehand and going over the questions they were going to ask you?
About, I don't know, 100 times. I would say more often than not, that's how it goes down.
That's got to stop. And the key thing about our class, other than the whole new pair of glasses of how to look at what you're doing as far as telling the truth that you want to be in court, and then the preparation required to get there, the other key thing is empowering police officers with the fact that you're way more in control of this whole process than you think. You're more in control on the stand than you think because you're the one who is there and you know the information. You know it because you prepared. But you're also more in control of what's going to happen with that prosecutor because you have the right to insist that they tell you what they are going to ask you. Now, folks, there is a perception out there that lawyers meet with witnesses and tell them what to say. This should never occur. A prosecutor should be in serious trouble for doing anything like that. I want you to tell the truth. You tell me what you're going to say, and you don't need to tell me now. You can tell me on the witness stand. I just need to know that you're okay with these questions that I'm going to ask you, because I don't know diddly squat about your dog and your canine training and how that relationship works and all the cool stuff the jury wants to know about you and your dog. I don't know how to ask you about it. And you know how I should ask you about it to get the right answers to the questions. That's why we meet. And prosecutors, we think we know. We don't know. We're not the witness, So we have to meet and hear from you about how our questions are flawed, how to change them and adapt them. And that's why we need to go over them.
I've also found it helpful to give, when you have a little bit of face time with the prosecutor ahead of time, because there's been a couple cases that you brought up the canine thing where I went out of my way to meet with the prosecutor to make sure that basically I said, hey, these are the things. I went with like a notepad and said, this is how I would explain this. Just hypothetically, if you wanted to ask me about this, I can explain it like this. And the point of that was, one, to make them feel comfortable with my ability, because the whole thing was they were going to go down the path of the reliability of my dog and what he can smell and those sorts of things. And using my training and my background as a dog handler, I can explain that in a way as long as they open that door for me. And so that was like one of those times where I needed to go ask that. And there's been other lesser cases in many cases, run-of-the-mill DUI type thing that you don't necessarily know what's getting challenged. And I think that's problematic. And it's one of those things that you need to, if part of your case is specifically getting challenged and the prosecutor knows that, one, for the cops, like, you need to ask. If you don't ask, then you can't blame anybody for not telling you. But two, I would hope that they would say, hey, just so you know, they're coming after the stop because of X, Y, and Z, or whatever, and tell you what it is so that like, okay, I need to, in my head, prepare for how I'm going to deal with difficult questions pertaining to me pacing his speed, for example, or whatever it is.
Right.
And this is a really interesting area because I want to make sure, I don't know if it differs outside of Arizona, but I do know this. In Arizona, we cannot, if there's something, the rule it gets invoked on exclusion of witnesses. And it means that Josh, as the case detective, can know what everyone says because there's a special exception that he can sit through the trial. But other witnesses can't know what the witness before them testified to. So I can't meet you in the hall and say, oh my gosh, he just said the car was red, wink, wink. You might want to describe it as red. That would be unethical, wrong. We don't do that. However, it is totally appropriate, and you would think it's a courtesy to people that every human being would want, hey, you're going to be asked about the color of the car, so just make sure you're focused on that issue so you can give your best testimony on it. Review whatever you need to review, do whatever you got to do, think about it, meditate, I don't care, but you're going to be asked a lot of questions about the color of the car. Preparation is the courtesy of letting the witness know what's on the menu for the day, and trial is not an extemporaneous event. It's not improv. We should not be going in there and being like, hey, I've never seen you before. I'm just shocked at the number of times I hear that witness and prosecutor basically meet on the stand in front of the jury. And we have demanded that these citizens give up their jobs and come down to court and sit there all day. And we haven't even done the courtesy of preparing by, letting you know that you're going to be shown a map. And maybe north isn't up on that particular map.
Right.
You need to have seen that before,
Yeah, and Jonathan's right. The best witness is the one who wants to be there, and preparing ahead of time is going to make you want to be there. It will make it a much more pleasant experience. It's when you prepare and when you know your case and when you've communicated with the prosecutor, you can go up there, and this is the culmination of your work. And so now you get to communicate that to a group of people and explain that to a group of people who don't know this case from Adam. And you get to go up there and from the very beginning, you can explain how you came to find the evidence that you found and what you did with that and what it means to you. Again, preparation is the key. If you're preparing, it's going to make it a much more pleasant experience being there.
Yeah, I haven't. One of my good friends that I work with on SWAT, and he's also a supervisor and involved in an investigative unit. Talks a lot about like if you have to look at your report, it better be for something very specific,
right? And
you should know exactly where on your report that is. Like you should have that entire narrative more or less down. And if there's something like, if you've got to go look at a specific time that something happened because you don't want to get the number wrong, that's one thing. But you better have very clear in your head what happened and what you did there.
Oh yeah, we cover that in the class as well.
Absolutely. Although go easy on Josh because he has one case where he has a 120-page report, so that's a little tougher to commit to memory.
Yeah, that's going to be tough.
So what advice would you give people on dealing with some of the questions they're going to get asked by defense attorneys on cross-examination?
Yeah, I mean, one thing I always tell witnesses, police officers, or other witnesses is that we're going to do preparation so that you feel prepared for the questions I'm going to ask, so that you're ready for the exhibits you're likely to see at trial. Certainly the ones I'm going to show you, but that I cannot, even when I'm at my best, I can't predict all of the cross-examination questions. So I'll try to bring up things you may be asked on cross-examination and prepare people for that. In the class, we also talk about the fact that your attitude needs to stay the same. I mean, Josh, we talked about Lelevere, but in every trial, it's the same way. But when he is on the witness stand, he has a really likable demeanor with the jury. He's leaned forward towards them. He's speaking into the microphone. He's looking at them. He's making eye contact with all the jurors. He's relatable, okay? He's talking to them like real people, and they trust him. That does not change when the defense lawyer starts firing questions at him. It does not matter to him if the defense lawyer is being mean or slow or fast or happy or sad. He doesn't care. He is going to be the same relatable, patient, leaned forward, engaged. And it sounds really simple sitting here in the podcast, but go live my life and go over to court because most people don't do that.
Yeah.
They change and they sit back in their chair. They get defensive. They lean away from the microphone. They stop looking at the jury. They start strangely looking at me as though I'm telling them what to say. The only thing I'm telling them to say is
the truth.
The truth, right? So I can't help them answer questions. I wasn't there. So, that's part of the cross. But then the other part is just, look, you've done all the preparation, but at the same time, you also do have to have a little bit of love of the excitement of the fact that you're going to get asked some things that are going to be a complete surprise and go with it based on the rules that we're trying to give you in the class, which include one really basic rule, which is that, if we got this far on this case, then at least the subject of your testimony, we've been through a defense interview, you wrote a report, you believe the things you're saying, right? So, I mean, if we got, if you said I checked those shoes into evidence and it's those Reeboks sitting over there, are Reeboks still a thing anymore? I don't know where that came from.
Let's go with it.
So if that's what you did, then they start asking questions. Well, isn't it true those were Nikes? In fact, one of the things that you have to be able to do if you're prepared, you studied, you're telling the truth, is you've got to be able to bring the jury back to planet Earth. Because if they were Reeboks, the cross-exam is not going to be, well, they were Nikes. It's going to be something that's trickier than that. Well, did you ever remove the laces this time when you try, sometimes these questions, people can get worried about, well, where are they going with that? And they can the result of that is that the witness seems like they're hiding something. And keep in mind, the jury is always looking at every single witness, as preposterous as this seems, they're looking to try to figure out, are you a liar or are you telling the truth? You walked into court never realizing that's what the jury's doing. You think, of course I'm telling the truth. I swore to tell the truth. I'm going to tell the truth. But the jury's trying to figure out, are you lying to them? And so any evasive behavior can be really misinterpreted. So What it all comes down to is getting back to the realities of planet Earth, usually, because if you're offered some preposterous counter defense theory, you just got to be able to explain, wait a second. This is what so the best example I can think of was a murder case I tried in Flagstaff where, and by the way, if you haven't been to Flagstaff, it's at 7,000 feet of elevation here in Arizona, where it is not exactly a swampy climate. It is still dry. It is high and dry. Okay, so there are pine trees. They could have, I guess, moss. I'm no biologist, but what you're not going to see out in the forest in Flagstaff is algae on the frickin' trees. Okay, the reason I bring that up is because I had a case detective on the witness stand, and he was an outstanding witness, really great, and he had done a great job through direct, through cross, and then the jury was asking him questions. And, some of these jury questions can come from left field, even more so than a cross-exam question could. So one of the questions was, did you look for fingerprints on the algae on the trees? And that, because this is a crime scene in the forest. And his answer? No. Which caused, Josh knows because he knows I would then have kittens. I would proceed to have kittens on the next break. Like, I'm sorry, do we need to take a tour of the forest out here? You tell me about all the algae you're seeing on the trees. Like, what are you talking about? Like, do you think that question could have had a little more explanation of the fact that there's not algae on those trees out there and that there is no medium where you might be able to collect fingerprints on the trees in the forest? Because, like, literally, you've got a juror there thinking that you might have missed something, and you miss an opportunity to explain there's a very good reason why I did not have the crime scene analyst come and do lift tape or, super glue on a way of collecting acrylamide or whatever, a way of collecting fingerprints on the trees in the forest. And so I bring that up not just to make fun of my good friend Casey Rucker. Hey, Casey, hope you're listening. No, I bring that up because I can't predict all the different flavors that this will occur in. You will get some question from left field, and it will rely on you taking the jury back to the reality of what you did, why you did it, and why you didn't do things that didn't need to be done.
Yeah, and I think, so adding on to that, I think it's really, really important to listen to the questions that are being asked and pay attention. If you've got questions that go from being one question to maybe three questions all rolled into one question, and this goes for the attorney interview just like it goes for trial, pay attention to that. And if you have a multi-part question that you're being asked, slow it down, break it down, and you can do that politely, respectfully. I mean, what I'll say is, so two parts to that question. Let me address the first part. The first part I'm hearing you're asking whether or not this happened. So let me address that. And then I think the second question you asked, or the second part of that, related to this. So let me address that. If you do that slowly, patiently, and reasonably, you're going to be able to survive whatever they throw at you, because we have the truth. I mean, they're throwing rocks. That's their job, and that's what they're going to do. But if I tell people, your job when you're testifying is you've got to be the most reasonable person in the room. And imagine that you are, no matter what's happened, people can be yelling, pounding a desk, throwing evidence across the desk in front of you. You have to remain reasonable. You can't go off. You can't be offended. We don't have it's not an option to get offended by how we're treated when we're on the stand. All we are there for is to help people understand what happened, to communicate that to them, and be the most reasonable person in the room. If you do that throughout and consistently, you're going to be able to survive whatever comes your way.
And a few of our instructions really work against us to the extent that prosecutors give bad instructions, like only answer the question, because what Josh is saying is that you're gonna think about the question for a second and think about all the parts of it. So, for example, we use a couple sample questions in the class. One would be, you didn't bother to collect the underwear, which would have shown if my client put his hands down the victim's pants. Well, there's a lot of parts to that question. So when that comes at you on the witness stand, you have to be prepared to say, I did not collect the underwear. It was collected by, if it wasn't, you got to own it if there's a limitation, if there's something you realize. People make mistakes. It's like, I didn't collect the underwear. I wish I had, or whatever, but a lot of times that question is being directed at somebody when the defense lawyer knows full well that another person collected it, so it wasn't my job to collect the evidence. And as to the point you're trying to make about DNA, I'm not an expert on DNA. But sometimes somebody could say, because Josh has put in enough items for DNA analysis, he probably would be qualified to say something like, I didn't collect the underwear. And as to the part about whether the underwear would tell us if my client put his hands down the victim's pants, I believe you're making an erroneous assumption based on my own understanding of DNA. And I can explain that if you'd like me to. I've seen him do stuff like that, and it's just like, oh, the defense lawyer will move right on from that, or let him explain, and then he does a great explanation. Because the explanation is that people can touch things and not leave their DNA behind. We see that. I'm sure Josh has had the experience of submitting guns for DNA analysis, and you actually saw it in a person's hands, and yet no profile comes back on the gun. So we know that happens. Another type of question that you would get would be, you would have done X if you thought it was important. You would have recorded, you didn't bother to record the victim when you arrived at the scene of the domestic violence incident. But if you would have recorded if you thought it was important. These types of qualifications about what you did usually involve you as the officer bringing the jury with you. I like to say back to planet Earth, but really it's to the exciting thing that you did. And you've done so much of it, you've forgotten or lost track of how exciting it is to the jury, especially because they're there in this trial and it's all they're focused on for a week or two or however many days. And so you got to be able to say, I need to take you back to that scene because when I arrived, I was not there as a detective to take interviews. I was trying to figure out if there was an assailant on the scene. I was trying to get medics there. I was trying to render the scene safe. And you guys even have I was doing the 1082, which means that blah, blah, blah. And by the time you're done, the jury goes, oh, I have such great confidence in this officer because he was so honest about that situation. He really painted a picture of it for me. So we're really losing opportunities to do that when we don't meet, prepare, practice, not practice the answers, but practice going over the questions that we're going to ask so you know what's coming. And then that's gotten the juices flowing about, talking about this incident, Yeah.
I refuse to give inaccurate, misleading sound bites in response to defense questions in interviews or on the stand, just because it'd be easier to do that. Is it easy to say, no, I didn't get any fingerprints off the tree? Yeah, that's a whole lot easier than saying, okay, I'm hearing if you asked whether or not I attempted to get fingerprints off the tree, I didn't, and there's some reasons for that, and I can explain that if you'd like to hear that. That takes a lot more work, right? But it's also accurate. That's the truth. There's a reason that we do the things we do and we don't do the things that we didn't do. And it takes a little bit more work, and you have to work through that, but it's giving them the complete picture, and it's honest. It's much more truthful than this soundbite. Nope, no, I didn't, because you're leaving all of that other information out, and it's important information.
And the thing about it is that I realize is that it's not because that truly was like the Josh Cheek of Flagstaff, the guy who was on the witness stand in that example. He's an outstanding cop, detective, and very diligent and was super prepared and committed. The one thing that people might not realize about trial is the level of sustained concentration required. Right. And so, I like to run 100 miles. I can't wait to do it again. I like feats of endurance, but some people don't. And so I've co-tried with other prosecutors and realized, people skip lunch and get sleepy in the afternoon. It's like you have to actually take care of yourself, whether it's hydrate or if you're a caffeine person, you got to dose out the caffeine in the right amounts. You got to do whatever it takes so that you're engaged with the jury at 4:45, the same way you were at 1:30 and at 10:30 a.m. And that's a difficult task, I think, for some people, but I think if we brace you for it, I think cops are meant to excel at this. It's a self-selected population where they should excel, because you guys will stand on a scene for the whole night long and stay awake and stay alert. You don't mind the rigors of like some physical demands as a group, so it's like, but we didn't warn you about it, that it would be that way. Because the last thing you thought is that sitting on your butt talking to people would be physically demanding, but it kind of is, because of the brain power required in the courtroom. You get out of a day of testimony, you're hungry.
Oh yeah, it's intellectually exhausting. Like even sitting through a trial, even if you're not testifying, if you're following, I recommend every detective, if you're the case detective, no matter what kind of case it is, you sit through that trial. You sit through as many trials as you can with the prosecutor. You use up the sticky notes. You communicate with the prosecutor, watch the jury, pay attention to what they're paying attention to, watch what the defense is doing as far as how they're handling witnesses on cross. I learn something new from every different trial. And regardless of whether I'm testifying or whether I'm at the prosecutor's table and paying attention during the trial, I'm wiped at the end of it, because it is sustained concentration throughout, and that's how it should be, in my opinion. And that's how you continue to improve as an investigator.
I've noticed that. Where was I going to go with this? I've noticed as a police officer that in many of the cases that I've been asked to testify on, the more outlandish the questions the defense is asking you, the safer you are. Like when they start going down those rabbit holes, it's like, okay, just like you said, be patient, explain what you need to explain. Don't get too frustrated. Don't get too defensive. Don't let them back you into a corner that you don't see. I remember one time I was on the stand and I had a defense attorney. We had a guy that we stopped for this brake light out, and he went down this rabbit hole about, well, you know how the new cars have the LED lights, and so it's a lot of dots? How many of those dots have to be out for it to be not working? And I'm like, well, in this case, back to the planet Earth thing, I said, in this case, it was a regular incandescent bulb and it wasn't functioning at all. And so based on my understanding of the statute, and he wanted to know about the history of the statute getting changed and all, we had a brake light statute here in Arizona that was interpreted to be a little bit too vague to be enforced as if one of your brake lights is out, but some of the others are working. And so that has been corrected by the legislators. And so now there's a new version of that law that is pretty cut and dry, like all of the lights on the back of your car have to work, right? And so we were going down this rabbit hole about how many of the LED bulbs have to be out for you to consider it to be not working. And I said, well, the statute says that all the lights have to be working. So if any of the lights are not working, then it's not.
Right.
And so we were going down this thing, and I was just kind of looking over like, how many circles are we going to talk about this? Because and so again, you just have to kind of entertain that, wait for the prosecutor will hopefully come to your rescue at some point and be like, okay, this question's been asked 5 times and answered. I think we could probably move on,
Right.
But there's no reason to get frustrated, because it goes to everything that we've been talking about, is that, they're trying to put on a show for the jury too. And if they get the best of you,
yeah,
for something stupid as brake lights, I mean, that doesn't, beyond the legitimate factors that you might be discussing, then you're just going to make yourself and the whole case take a hit for that.
Yeah, if you react in anger or frustration up there, as difficult as it can be, if you react with anger, you're playing to the defense's strategy, which is to make you look like you're not being truthful. And we don't have that luxury. We don't have the luxury of reacting with anger or frustration while we're up there, as difficult as that can be.
And I would offer that even if, I think you can and should correct things, that if they try to walk you down a path that isn't true, you should correct them, but you got to do it in a politeful way. I remember I had another one about DUI and field sobriety testing, and they told me that I guessed the number of things that the person did wrong. They're like, so you did this test and you guessed 3? I said, I wouldn't say that I guessed.
Right.
I absolutely observed these 3 things. It wasn't a guess at all. Those are standardized and validated cues and a part of the test.
Right.
So it's like you can address those things in a personable way.
Sure.
Well, that's a great example, because why would it be that a defense lawyer is asking you that, the guess? Because they've had it work.
Yep.
And why has it worked? It's, again, I think it gets back to because we haven't done a good enough job of the type of class that we're doing, where we're empowering people. We got to let you know that you're more in control than you think, because nobody is allowed to present something other than the truth. You swore an oath to tell the truth. So think about it this way. If you didn't guess and you're agreeing that you guessed, you're lying.
Yeah.
So you can't do that.
About them
and
apples.
So, you can't be misled. You have to have your guard up. You have to be engaged in this. And I think when police officers realize, oh, it's a battle of wits, but it's not about a bunch of stuff in the law that I don't know that this is, because why do cops hate coming to court? We talked about a lot of the reasons earlier, but and I'm not saying all police officers do dislike coming to court, but the ones who dislike it in part because they think that there's something mysterious that's going to happen where they're going to get picked on, exposed, shown to be inept, something, and they don't really know how. And it's some trickeration that the defense lawyer knows really well and that they don't know. And that's a false narrative. Okay. What's actually happening in court is that we're having a search for the truth. You're the one who was there. You can tell us warts and all. If any prosecutor ever tries to massage your testimony to make it different than the truth, call me. You have my cell number. I mean, that's not going to happen in Pima County. And so that means that you're vested with the superpower Josh referred to at the opening, which is that you get to just tell the truth. Yeah. And then you can walk in with supreme 100% confidence and just focus on the concentration and the need to correct misstatements like that. I mean, there's another way that misstatements get made besides inserting the word guess, and it's to get you into a pattern. So you went to the scene, yes, and it was late, yes, and it was dark, yes, and you got out of your car, yes, and you were wearing your uniform, yes, and you opened the door, yes, you walked inside, yes, and then you didn't bother to record anything, no. And it's like, wait a second, why did you just say you didn't bother to record anything? You're looking for a killer or whatever you were doing. I mean, it wasn't just that you didn't bother to,
Right. What advice would you give if an officer said something different in their interview a year ago and is now on the stand testifying and says something different, and then they are confronted with a transcript of that interview that says, well, in your interview this day, you said this. And let's assume that there wasn't any intentional, that they're not lying about it. They just either misspoke or they're confused, or one or the other one or the other is inaccurate, right? But how should they approach that?
So, how I would say first and foremost is review your interview transcript prior to your testimony. Review your case prior to your testimony. You should know all of that stuff. And that goes back to being prepared. And that way I'm comfortable. I've reviewed that because that's why they're doing the interview in the first place. One, it's so that they can do fact gathering and they can gather facts that maybe they don't have or they don't understand from looking at the reports. Two, they want to gauge you and what kind of a witness you're going to be. But three, they're also going to want to put you on record. And if you if you slip up and you make a mistake, they want to capitalize on that. So first and foremost, I say, just like you review your cases, review your interview transcripts and review that and go over that and be familiar with that. And it helps you review for trial because it'll help you get you into that mindset. But if there's a discrepancy there, I think the best recommendation I can give is to be honest with the jury and say, look, these questions are really important. I want to make sure I'm giving accurate answers to these questions. And so I'm giving you that answer right now. If there's some kind of a discrepancy between what was said during the interview and what was said right now, I don't know, be honest about the reasoning behind that. If there's nothing malicious about it, if it's a misunderstanding, explain that. I mean, if you are communicating effectively with the jury, they're going to see that you're a human being, and human beings can make mistakes. And if that's an honest mistake, explain that to them.
Yeah.
I mean, there's nothing wrong with You can't. None of us are perfect. You can't be perfect, and you're not going to be perfect up there. You just have to be honest.
But this is why preparation matters, is because, and Josh, we've probably done this, is that, Josh knows if he finds something that he said that was wrong in the interview, the sooner he tells me about it, the better, not because I can get ready, because I disclose it to the defense.
Yep. We're
going to run, not walk, to let the defense lawyer know, hey, we found a discrepancy here. He said the car was green. Now he thought about it and he knows it was maroon.
Right. I can think of a very good example of that. There was an issue I had in a report where I had synopsized an interview, and I realized during the attorney interview or just after the attorney interview that I had taken a chunk of the synopsis and put it out of place. So it was misleading the way it read. And I think I recognized it during the attorney interview. And it was with a defense attorney. He was with the public defender's office. He's now a pretty decent defense attorney, a high-dollar defense attorney here in town. But I saw it, and during the interview, I said, hey, you know what? So you need to know this block of the synopsis is actually out of place. And let me explain where that's at. It's out of place starting from this line, going down to this line, and it actually should be here, because as it reads, I can see how you could think that this is being said, but that's not accurate. And I just want to make sure I cover that. So I covered that, and I think I covered it in the defense interview. And then on the stand, I was being cross-examined, and it wasn't going well for the defense. He wasn't gaining any traction. And he went there. He said, so this is a police report that you generated documenting this incident, isn't it? And I said, yes, it is. And police reports are important, right? Oh yeah, you bet you. Absolutely they are. And yet this report contains false information, doesn't it? I said, so I need you to explain what you're asking me. What about this police report is false? Can you be more specific? And then he goes right to that portion of the report. And I can say, no, you're absolutely right. There is a portion of this that's out of place. That's why I discussed this with you during a previous interview that we had prior to these proceedings. And I explained how that happened. But you're right. It's very important to recognize that, yes, a portion of this is out of place, but that's why we discussed that. And so I don't know what he thought he was going to be getting out of that, but just be honest. This was a mistake. I made that, and I corrected it as soon as I could with him. But
generally speaking, I don't think, at least in the cases that little things like that have happened to me, whether it's something in a transcript from an interview or you speak something that was in your report. When you look in your report, you're like, oh, you're right. Actually, it was this. It's, it's not the end of the world.
Right.
Most of the time, it's just, like you said, be human about it and just go, oh, you know what? Yeah, I mixed that up. It's actually, the car was actually red, not green or whatever. And
right.
Just say it.
It's they want to gauge your truthfulness, and they're not going to gauge your truthfulness based on something trivial like that, as long as you're being honest and communicating effectively with them.
But I mean, to me, I want to come back to the fact, I want to know about it. I mean,
Sure.
I'm going into trial. I tend to go to trial on important cases. Not that every case is not important, but I mean, this is somebody's liberty or life at stake in terms of the defendant in a criminal case.
Absolutely.
And they deserve to have the information. So the minute we find out we made a mistake, we disclose it, and we find out we made mistakes because we study and prepare.
Right.
And it's just not optional.
Right.
And I'm not saying that to get on the case of police officers. I think it's incumbent upon prosecutors to set that tone. And we've, I think, taken good steps to change that culture and hopefully implement that type of approach in criminal trials. But it's important to me because police officers always have to tell other people all the rights they have. It's so important for me to police officers know they have the right to talk to the prosecutor, to demand the prosecutor prepare them for trial by letting them know what's going to come up, what's going to be asked, what exhibits are they going to be shown. And if you're having those conversations, we discover problems like this. Yeah. We get them disclosed, and then we can deal with it. And heck, if it's a big enough problem, we'll drop the case, we'll plead the case, whatever is right in the interest of justice. Like, that's what we all want, is the right thing to happen in the case.
How do you approach offering a plea versus going to trial? Like, what is your general philosophy there on whether or not someone gets a plea and what their offer is going to be?
Well, I think, first and foremost, you always have to be thinking about community safety, right? So that we will not offer a plea if the plea puts the public at risk. but there has to be an asterisk or a caveat because I'm not a magician. I only have one tool to work with in the larger sense, which is evidence.
It's a superpower, not magic, right?
Correct.
to prove, telling the truth is a superpower at trial with the jury. The quality of the evidence in the case, I do not control, and nor does Josh. And I mean, we wish we could solve all cases and have beautiful evidence, but sometimes we don't. And sometimes you have probable cause and a case gets indicted, and as you go forward, real problems emerge with it. And these can necessitate a plea, because what people don't understand is that trial in a case with weak evidence is a risk of a not guilty verdict. And if you have a dangerous defendant who did a dangerous crime with weak evidence to prove it, now you have a real problem. Okay? Because, from a negotiation perspective, you're not holding all the cards. And if I could have all the jurors in the universe say, no, Mosher, we'll be with you, even if you have evidence that's pretty difficult, then I would never have to offer a plea. I mean, it would be difficult to try every case that happens. Currently, we try maybe 6% of the cases, maybe 5% of the cases that are charged. So 95% of cases are resolved by a plea. That's not because we're scared of trial. That's a pretty high trial rate. Right up the road in Phoenix, it'd be about less than 2% of cases getting tried. So, pleas
they charge marijuana as felony still. They still charge marijuana possession, simple possession as a felony still. That's
yikes. Pleas are a necessity of the criminal justice system. So what I look for is, 1, do I have a risk to the community? 2, do I have problems with my case? And then 3 is, are the police who investigated this case and care a great deal about it, as well as if there are victims, are the victims, and police officers giving me input that allows me to properly assess whether I'm doing the right thing on this plea? And I cannot always do what the victim wants. I cannot always do what the police officers want, but I owe it to them to take that into consideration. I mean, it's a statutory mandate in terms of the victim, but I also like making sure that we're right with police agencies on our pleas whenever possible. Can't be 100% of the time. I mean, look, there are cases where we don't charge them where the police agency wants us to charge, and vice versa, because we have to assess the evidence when we're making that decision.
Yeah, and I mean, I've seen in homicide cases where, it looks like, hey, we've got a good strong case here. Present it, it's issued, it goes to grand jury, and then the actions of family members of the victims, the actions of friends and or witnesses, in this case, they continue to either reach out to me or I conduct follow-up interviews with them, and I get information that just is hurting this case more and more. All of that gets documented in reports. Like, my case doesn't stop after, my case doesn't stop after the grand jury presentation. All of that gets put in reports, all of it gets recorded, all of it gets disclosed to the defense. And I've had instances where, man, this case was great, 4 months ago, and it's just gone down the tube since then because these people are just getting in each other's way, and all that information is disclosed. And so we have to sit down and have a conversation. Like, look, this is a fact. This is what happens, and these witnesses who looked great 4 months ago, not looking so great right now. And those, in my experience, those are the cases that end up getting pleas.
And this is a really I'm really glad you asked this question. It's an important conversation to be having, and here's why. We started out by talking about public confidence in the criminal justice system, and there's a lot of public outcry over examples of whether it's prosecutorial misconduct or police abuse of power. I mean, I'm not not anything the three of us have done, but we're held to answer for it. However, let's take kind of a different approach. There's also a lot of public disdain for prosecutors because, this plea bargaining that happens. And we've really got to adjust people's attitudes around that. I mean, for example, I've been taken to task for offering pleas on cases where the evidence is absolutely not viable. I had a case where both the defense expert and the state's expert said that the defendant was guilty except insane. So
Sounds like
I mean,
trial
in
material.
that case, you just don't have a lot to work with. So it can't be the case that prosecutors. This is what I mean when I say we're accused of being too soft on crime and too hard on crime. Nobody wants an innocent person to be convicted, but you know how you avoid convicting an innocent person? You don't go to trial based on weak evidence. So look, if the evidence is weak and trial is risky, it can result in a plea. But if the evidence is really weak, you might even have to dismiss the case. And we as prosecutors are continually attacked for decisions we have to make around the strength of the evidence. And we need the public to understand what we're trying to do is do the right thing by following where the evidence takes us, not just where our emotions do.
What about where I've had a number of cases where a police officer goes to a call where this guy is, we'll just say, driving a stolen car, but he's got the keys and the story is this and that and the other thing and whatever. And maybe the stolen car is not a great example, especially a key case, because those are pretty crummy. But where I'm going with this is, imagine a case that is otherwise, it fits the statutory requirements, but their understanding of the local policies is that that case is not going to get issued. Should they arrest that person?
So that's going to be on the officer, on the detective, not on the county attorney. That's a big thing with us, and we cover that in the class. It's like, look, if you ever find yourself in a position where somebody at a scene is saying, well, we need to call the county attorney and see what they think as far as whether we should make an arrest, something has gone awry. That's not how, we take ownership of our own decisions, right? And so that's a decision for us to make. And I think it comes down to, like I said, look, if there's probable cause to make the arrest, then absolutely, you can make the arrest. And if that's the safest and most practical thing to do at that point in time, then that's what I'm going to do. If, however, I'm looking at a case and saying, okay, is there probable cause technically to make an arrest? Sure. Is it likely to get issued? Probably not. Does this person present a threat? Is this dangerous? What's the worst thing that's going to happen if I don't arrest this person tonight? What's the worst thing that's going to happen if I do arrest this person tonight? And, you got to make a judgment call in those cases. I mean, certainly we've all done that where we've had cases where we've made an arrest because there's probable cause and then the charges ended up not being issued. It doesn't mean we did anything wrong necessarily, but I think there's a time for long forming something and not making that arrest and documenting everything and presenting it as a non-arrest. And there's a time when somebody needs to be arrested and go to jail. And it just comes down to do they present a threat? Liability wise, what's our responsibility to the community, to this neighborhood right now?
Yeah,
but can I chime in on that?
Yep,
because
absolutely.
I mean, what your question is, what should we as police officers do if we think the county attorney won't charge a particular category of case? And that worries me a little bit because I happen to know that there's rumors that bounce around. So, for example, one time not too long ago, I heard that the county attorney's office wouldn't pursue cases of bicycle theft. Are you kidding me? I'll take them myself. I mean, give me a bicycle theft where we can prove it and we'll get after it. So I don't know where that rumor got started, but it's simply not true. It's like if a police officer has a bike theft victim who's going off in their ear and lighting up their phone, do they just say, well, the county attorney won't charge it? Or did somebody come down with a case we thought was too weak to charge, and so we didn't charge it? And then they say, well, the county attorney just won't charge. Rumors get started in all kinds of ways. But I'll say this, I'm not aware of statutes where we simply decide not to enforce them. Now, if I'm elected, by the way, personal possession of marijuana, I'm not going to be charging those types of cases, and I think there's a legal basis for it that I could explain, but that's beyond the show, and I don't think that's what you're talking about. You're talking about things like burglaries or car thefts or prohibited possessor cases, and we take all those things seriously, but let's talk about prohibited possessor as an example of this, because that's where I cut my teeth as a prosecutor. So if you're a felon and you're in possession of a firearm, that's a crime, and we prosecute that. And those cases are difficult to win at trial if the gun is, for example, in a common area. Let's say a gun is in the passenger seat in a car, and there's multiple people in the car, and you have the driver charged. That's a difficult case and may not get issued. But that doesn't mean that we're not in favor of enforcing those laws. It's that we got to follow the evidence to the cases that we can actually prove.
Yeah. And as a follow-up, I know I come at you with some examples, but the other direction I see this play out is, for example, if you were to go down this path of reading a robbery statute, and you've got a guy that did his shoplifting, but then pulled a knife on someone that tried to stop him, and there's some games that get played about like, well, I mean, that wasn't really a robbery. That was like a guy that went in there, and you could see where someone could sit there and go, no, that's a robbery, dude. That's not like a guy that just shoplift a DVD out of the DVD section at Walmart. That's a guy that, now used a weapon and a threat of harm to get, and so you see some games get played around with that. And I think there's two parts of that discussion, because on one hand, you can acknowledge that, well, okay, this isn't the guy that like plotted out the convenience store robbery and went in there with a ski mask. This was a guy that was cornered and maybe out of an act of desperation, like showed his knife.
Sure.
So there's one angle where it's like, well, by the statute, yeah, it probably still fits, but by the bigger picture, I could see an argument where, yeah, it fits, but at the same time, those aren't necessarily the same thing from the state of mind of the bad guy, right? Or the criminal.
But I mean, if you're a tried and true prosecutor, you look at that whole discussion and you go, well, that's maybe not as significant as you're making it sound, because an armed robbery is 7 to 21. If you go in with a knife and you threaten to get the Doritos and you grab them, Cool Ranch or even Salsa Verde, that's 7 to 21. However, if you brandish that weapon as you're walking out the door, that's an aggravated assault. That's 5 to 15. So how much do you want out of this guy? What do we need to do? Because we have a perfectly good aggravated assault on the facts you just talked about. So, I guess the reason I bring that up is because as a prosecutor, I've always been a big fan of dropping or adjusting the charges to fit the crime so that the jury suffers the least in terms of having to deal with charges that don't precisely fit what we're dealing with. Make it easy for them by not overcharging or just having the right, we could use like a lawyer's word, gravamen. What is it that really captures the harm of what was done here? And I think that's an ag assault with the knife.
Yeah. Most cases, I mean, and granted, that's just an example of one, but I hear stuff like that where, on the radio, guys will go to these calls and you'll hear, the suspect left and this and that car. Here's his description, and I'm going to go look for the guy. And they say, oh, actually, disregard. We don't have a robbery. We actually have a shoplifting and an assault, or shoplifting and threats. And I'm like, interesting. But again, I know that in many cases, or at least the perception is, people wouldn't take that case as a robbery. And so I'm curious what your guidance is to officers that are thinking about those sorts of things in the field. Philosophically, what would you tell them in terms of their decision-making and how they're going to describe a crime? Should they stick to the statute?
Yeah.
Should they use their best judgment?
I think they go by the statute. We should never find ourselves in a position as an officer responding to a call saying, yeah, technically this is a robbery, but you never know what those lawyers are going to do in the county attorney's office. So I don't even know if we should even bother with this. Like, why? Maybe we shouldn't. Like, if there's probable cause to make an arrest and if it's somebody who's pulling a knife on people, that's a public safety issue. That person needs
or an airsoft gun. That's another
Correct.
one I see a lot.
That's somebody who needs to be arrested. If there's probable cause to arrest that person, they need to be arrested. And then if for whatever reason, given the facts and circumstances of the case, if the county attorneys later on decide, no, this is not something that we're going to be issuing charges on, okay, that's fine. But we should not be dictating whether or not we arrest people when we have probable cause to arrest people especially for violent offenses based on what we think the county attorney's office may do at some point later on.
Yeah, and I'm not aware of any policy in the existing administration, and I certainly would not be in favor of one where we're, as a category, not charging cases where people use force to get property as robberies,
Right.
which is exactly what a robbery is in the statute. And it's an armed robbery if you're going to use something like a knife or a gun. And I
think first of all, I think it probably happens at a lower level. I think that's probably an internal thing, not an external within the police agency, not at the prosecution level. It might be maybe shaped by whether or not things historically have been prosecuted or charges issued. But where I'm going with this is I think there's a lot of like people's own mental gymnastics that are happening when they do those things. Whether it's they think, oh, the county attorney is not going to touch this, true or not, like Josh is saying, that's not really the point. Like if you have probable cause and an arrest is appropriate, then just just make the arrest.
Right.
But so like that shouldn't even really be the concern to begin with, right? But like those are the mental gymnastics that people play. The other one that I hear is, well, he stole the stuff and then outside in the parking lot when he's getting chased down by the clerk, he pulled the knife. We're calling those two separate misdemeanors instead of he was facilitating his shoplifting with the threat of a knife.
Yeah, and I think it's based.
It's
they're going to have to make a judgment call there.
Yeah.
But and you can talk you can talk yourself out of doing things a lot, and that's not necessarily the right thing to do. But it's a judgment call based on the scenario that you're given.
Yeah. My last question is, if cops get up on the stand and they are explaining something in detail to a jury, and like I mentioned earlier, doing DUI investigations and horizontal gaze nystagmus, which is an eye test that we do to measure impairment. In case you're listening to this and you haven't heard of that before, how much should cops dumb stuff down? If it's something technical like that, or DNA is another example, to what degree should they simplify things to make it easy to understand to the jury?
So I look at it like when I talk to cops about how they should explain either whether it's something complicated or whether it's seemingly common sense, explain it like somebody who has no experience with this. Don't belittle people and don't talk down to the jury, but explain it like you're trying to help somebody understand something, like maybe they're not familiar with it. So like a real good example is every day, anytime I go out on a call out for homicide, we go out and we get a patrol briefing. And then assignments are given, and then we go out and we do interviews, and we have a search warrant, and we process a scene. Well, if I explain that to a jury, to me, I just basically described that call out. The jury has no idea what I'm talking about. So I have to stop and recognize, okay, all that stuff that I just covered in a synopsis, there's a whole bunch of missing parts and pieces that the jury's not going to understand. So I can say, so this is how a call out works. I get called from my boss. My boss is Sergeant Marco Borboa. My boss will call me out and he'll tell me, look, there's a homicide investigation. This is where it is. I go and I meet with other detectives and I meet with patrol officers. We usually meet within the crime scene, outside of the crime scene, but within some crime scene tape. And there's a briefing. And this is what a briefing is. And this is how a briefing works. And for me, it takes a lot of time to do that. And it may seem simplistic or oversimplifying, but all of that information, there's going to be one juror on that jury who's going to be like, oh, okay, yeah, that makes sense. That's going to be necessary, that level of explanation. And again, you're not belittling people or speaking down to them in any way, but don't forget that this is not the everyday for this jury. This is something out of the ordinary for them, and the vast majority of them are going to have very little, if any, experience in what you're talking about. And so I think the more explanation, the better. Certainly, you don't want to turn what needs to be an hour's testimony into 4 hours, but you can take the time to explain what it is you're talking about. That always seems helpful to me because, one, it bridges that communication gap. It lets you speak to the jury. It lets them gauge you and hear you. And that's going to help later on in your testimony, but also it tells them what's going on. And so when you refer to the briefing or another witness later refers to the briefing, they're going to think, okay, yeah, that detective, he talked about that.
That was the thing with the thing.
That was the thing with the thing in the place.
you all don't realize how fascinating your work is, and so it's not one juror, it's all of them that are into that when Josh does that. And this is a great closing question because it comes back to what we're talking about, changing public attitudes about police and prosecutors. And with respect to police, the more that the public knows about what you all do, the risks you take, how you face them, the protocol you observe, why there are those protocol, what your daily lives look like out on patrol, the more we win that battle for public confidence. And what I see in trials is because we do it a certain way, and when I say that, what I mean is we elicit this type of testimony where it's more detail, more explanation, more couching things in terms that the jury can understand. So if you say I was code 1020, then you explain it. The more we do that, the more the people who in jury selection said, I don't really like the police, by the end of that trial, you can tell that they are fully on board with what you all are doing because y'all came to court, talked about what you did, were open and honest about it, and they got a glimpse into an occupation that's like honorable, serving others, taking risks. I mean, it's a big deal. And how can we sweep that under the carpet at a trial and hope to do our best? It's crazy. So talk about it, give the details, make it real for these folks.
Those are great points. And on a personal note, what I would say about, and I've not a detective and certainly not an attorney, but what I would tell cops about testifying, I've gotten to do it a number of times now, and these are not the demons that should keep you awake at night. Going to court and getting riled up by a defense attorney about some, an error or two in your investigation is not the thing that should keep you up at night. The thing that should keep you up at night is, number one, getting it right in the first place. It should be a much bigger concern of yours. And then two, like Jonathan said, those risks that we have out there and all those things deserve a lot more of our effort and attention in terms of being worried or intimidated or scared or afraid of than going to court. And to follow that up with the importance of being good at going to court is, this is a huge part of your job. What good are you at catching bad guys or, apprehending criminals if you cannot seal that deal when appropriate? And obviously we've talked a lot about some of the philosophy, like, are they all bad guys? No, they're not all bad people. They just did bad things, and those are all well and good. But just, bigger picture, I just want you to think about, like, this is a huge part of your job. And I have seen the way some of you write out there. And yes, I'm talking to every cop that might be listening to this show. I've seen some of the reports that people write, and I don't understand why it's so hard, but the way that you can speak in public and convey and communicate yourself and what you did to people, both in your reports and in court, has a big impact on the outcome of these cases. And so I hope that you're taking Josh and Jonathan's words to heart, and you're going to incorporate that into preparing not only for those individual court appearances, but also to be able to communicate those in a compelling and convincing way. Because in my eyes, it's not that hard, but it does take work. You have to get out and put yourself out there. You have to project. You have to be confident. And the way that you do that is by practicing and doing it. Go out and teach. Go out and do public events where you have to speak in public. Get good at that as a skill, because I do think it's a critical component of our job. And it's amazing to me that I see cops speak to people all day long, and with a command presence. That was like, command presence, I think, is a bad word in law enforcement nowadays. But when I first started, and I'm sure maybe when Josh, somewhere along the road in Josh's career, that made a big thing, was command presence, and that was, we can do that really well at 3:00 in the morning on a domestic violence scene. Why is it so difficult in court? I don't get that. And right. So I want to see guys get better at that.
Yeah, and just as a side note, I would throw it out, call load permitting, supervisor allowing, anytime you get a chance to observe somebody, courtroom testimony, or observe a trial or sit through a portion of a trial or a day of a trial. If you have that opportunity, take it. The more experience you have in that courtroom, even as an observer, the less foreign it is going to be to you, and the more comfortable you're ultimately going to be when it's your turn to get up there and give your own testimony.
But remember, you could stumble in there and be watching somebody who's not doing it the way we want. So watch with a critical eye. And here's the other thing I'll say is, make sure that you don't change who you are, because the reason you are a great witness, because everyone listening to this will be a great witness, is because of who you are. So if you're quiet or you're shy or whatever, embrace it. All right. You're not trying to be somebody different when you take the witness stand. You're trying to show the jury what you know and that you're telling the truth. And being yourself is just fine. You just got to be able to communicate the information. So it might take a little bit of an uptick in the volume if you're a shy, quiet type. But we're not looking for everyone to come off the same way to the jury. Being who you are is just perfect for this role, as long as it's the person who wants to be in that gosh darn witness chair the day you're testifying.
Yep. All right. Well, any other points or things that you want to add or get into before we finish up?
I'm good.
I'm good.
Thanks for having us.
Thank you.
Really appreciate it.
Absolutely. All right, guys. Well, this episode was brought to you by Ride-On Optics. I use Ride-On's binoculars on surveillance operations, and they are nice and compact. The glass is super clear, so if you need to get you a set or are in the market for a pistol red dot or scope, make sure you go check out Ride-On Optics at rideonoptics.com. They have the best warranty in the industry, and their good guy discount can't be beat. Again, their website is rideonoptics.com. Also by Dry Fire Mag. Dry Fire Mag solves the common and annoying problem in dry fire of constantly having to rack the slide to reset the trigger. With a Dry Fire Mag, all you do is clear your gun, load the training magazine, and work on your trigger work. You can do follow-up shots, and you don't have to deal with those interruptions. You can go check them out on dryfiremag.com. Make sure you subscribe to the show. We put out new episodes on the 1st and the 15th of every month. You can find us on Facebook, Instagram, and Twitter. We are at TAC Tangents. If you want to support the show, you could go to Patreon, give us $1 for new episodes. That money's going to go right back into bringing you good content. And if you want to reach out to us with questions or feedback, you can go to the website, tacticaltangents.com. Click on the microphone. If your question or your comment is good, we'll feature it on the show. And that's all I got. Guys, anything else? Last thoughts?
Nope.
All right. Thanks for being here. Good talk.
Thank you, sir.